ಸಲ್ಲಿಸಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಮಾಡೋದು ಮೊನ್ನೆ move ಮಾಡಿ.
This petitioner have taken charges, project manager was getting
What do you want? What do you want? For what? What is the urgency?
I disturb the petitioner again, even after orders from this court also.
How will the other side know that you moved?
Lordship will serve the copy also.
And they'll say they not brought the file. They'll again ask for an adjournment.
No, your lordship, respondent is only state your lordship.
Obrena.
State a stay your lordship.
Monday Raja, Bharat.
After seeing the approvals granted by the superior authority.
But 2:30 again antadu.
To the agency without they are initiating this, the suspension order was also initiating.
ಮಾಡಿಲ್ವಲ್ಲ ಮಾಡಾದ್ಮೇಲೆ
Preemptive.
preemptive ಆರ್ಡರ್ ಕೊಡ್ಲಾ ಸಸ್ಪೆಂಡ್.
You ask go to the address of that.
Please wait.
Page number 10, page number 40 to 44. Page number 11, page number 45 to 47. Page number 12, page number 48 to 55.
Yes. $50. In adjournment ಮಾಡ್ಲಾ ಬೇಡವಾ?
But I am not permitted to examine.
Get him at 4:30.
Okay.
You cannot move hearing on I, you will have to wait. Inobra move over 10, still number 10. $16. ಏನ್ ಮಾಡಿದಾರ? ಅಲ್ಲ ಇದ್ಯಾವ ಹೊಸ ರಿಟ್ ಪಿಟಿಷನ್ ತಾನೇ ಅದು. ನಂಬರ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಕನೆಕ್ಟ್ ಮಾಡ್ರ ನಂಬರ್ ಇದೆಯಾ? Post RP number, per number, so on, so along with this writ petition. 10 no. We list on.
Okay, spoken to number 1. Yeah.
The council has moved a memo seeking for correction of the name, initials and other details of the petitioners. The errors as stated in the memo are permitted to be corrected. ನೀವು interim prayer ಕೇಳಿಲ್ಲ, ನಾನು interim prayer ಕೊಟ್ಟೆ. Then you should not tell me How can I grant an interim prayer when there is no interim prayer at all? It is notice that I'll simply say it'll be the same order but without the interim order.
Matter. Case number 3.
16th is same stage.
Case number 3.
ಅಲ್ಲ ರಿಲಿಸ್ಟ್ ಅಂದ್ರೆ ಏನ್ ಸ್ಟೇಜ್ ಇತ್ತು ಅದಕ್ಕೆ ಬರುತ್ತೆ ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ರಿಲೀಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಆರ್ಡರ್ಸ್ ಇದ್ರು ಅವ್ರು ಅಲ್ಲೇ ಆಗ್ತಾರೆ.
Easy to take notice for R1. Who appears for KRI DL? Devendra could take notice for R2. Really strong.
Case number 4. Naresh Shah.
Fish for the assistance of legal practice employees. And challenging. And there is a provision in the regulation. And also it is a covered matter.
TP Mutana to take notice for respondents. Really strong. For Kursi Mukspurdine. Why do you want an interim order? I'll have it next week. Your survey copy today itself. We'll dispose it of next week.
18. Case number 5. Artificial separation. Covered. Case number 30.
It is not in dispute that the issues raised in this petition is covered by the judgment rendered in WP 18766 by 2010, which was disposed on 4th of July 2012, and also confirmed in appeal in writ appeal number 42 bar 2013. In view of the above, this petition is also disposed of in terms of the order passed in WP 18766 bar 2010.
Case number 6. Ashik Perez.
Forest field workers.
Or extension of the agreements as per the provisions of minimum market act. An application will be taken on the ground and because the industry is running under loss. Let's be handled. Minimum wages.
ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇಲ್ವಾ ವ್ಯಾಕ್ ಕೇಳಿದೆ DGA to take notice for respondents 1 to 4. ಇವ್ರಿಗೆ ಯಾರಿದಾರ ಮೈಸೂರು ಪೇಪರ್ ಮಿಲ್ಸ್ಗೆ
ಬಿ ಆರ್ ಜಿ ಸುಧಾಕರ್ ಡಿಸ್ಪೋಸಲ್
ಬಿ ಸುಧಾಕರ್
ಬಿ ಸುಧಾಕರ್
B Sudhakar is there to take notice for on number 5. DGA to take notice for R1 and R2. Shri Doctor is there to take notice for R3. Relist on. Just along with.
Number 8. Chandrasekhar.
Along with WP number 2419/2022. 16.
Post along with so and so. 16. Till then, the impugn order in so far as list to the petitioner and third respondent shall not be given. And there will be permit.
Number 9. Number 7.
Yes.
Pay parity with whom?
Pay parity was with government employees or other. Government employees or the state.
AG to take notice for R1 and R2. Issue notice to R3 and R4. Engineering college.
He did.
Maybe you should have made the ACT a party. KT ಹೋಗ್ಬೇಕಲ್ವಾ? VWE, rural drinking water and water sanitation. ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? Copy those. I'll pass it over. ನೋಡಿ ಒಂದ್ಸಲ. I think there is a government job.
User examination. Another examination. Due to the technical problem, the article is not downloaded. That 17 candidates are not downloaded. This is the problem of the opponent.
What is the prayer in the reputation?
We are opposite to getting the final exam. Because the air problem not come.
What is the next step?
Age is also part method. Opportunity is last method. Because of their problem. Although there was already some outside. Opportunity because of their what that send to the post, but we not receive any post. At least they may send an email also. They cannot do that.
Now, if you have raised a claim 6 months after the exam, what can be done? You are at. No, but the last two lines says ಪರೀಕ್ಷೆ ಪೂರ್ಣಗೊಂಡ ಅಂದಾಜು 6 ತಿಂಗಳ ನಂತರ ಪ್ರವೇಶ ಪತ್ರ ತಲುಪಿಲ್ಲವೆಂದು ಅಭ್ಯರ್ಥಿಯ ತಕರಾರು ಎತ್ತಿರುವುದು. So where is, what is it to show that you had raised an objection immediately, that it was not being downloaded?
Immediately we approach the.
ಇರ್ಬೇಕಲ್ವಾ ಏನಾದ್ರು ನೀವು ಲಾಯರ್ಗಳು, ನೀವು should not have anything to show that you made an application or you submit a representation that you are not able to download the hall ticket.
Of course, before the resulting also we have got result ಆಗಿತ್ತು. So but
ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಹೇಳ್ತಿಲ್ಲ. It was published that the hall tickets can be downloaded from the internet. According to you, you were not able to download the hall tickets. Should you not immediately give a representation? So there's a technical problem, please resolve it. If you have done it, please show me the document.
So 24th is examination. After 22, they first to get the argument.
Where have you given a representation at that?
We are staying in Rajam. We phone call, we meet at the office. After that also, we after examination also we can.
Now the exam is conducted, then they are already appointed.
Already process is completed.
So then what is that you want to do now?
Even also.
You want a fresh exam to be conducted for you?
Now, 20 candidates are just trying.
70 candidates are not before me, only 2 people are.
Because now my leaders is already age is past.
You wait for 6
Because of
months,
their fault, we lose the opportunity.
assuming that they were at fault. You should have raised a complaint immediately. Show me some document to show that you raised a complaint.
Totally opposite. Totally opposite. Before announcement of the result, we give a representation. Representation for this announcement before.
That is not the point. If you wanted to take the examination,
Is to liberty to give to filing examination. Next examination is liberty to write examination. Because of their fault only she is suffered.
what is there to show that it is their fault? Show me some document.
They only.
They are saying that they sent the all tickets by speed post.
It is not disturbed. At least they may, at least.
ನೀವು ಕೊಟ್ಟಿರೋ ಅಡ್ರೆಸ್ಗೆ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ, ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಅವರು?
At least I not disturbed. Our apply consider. It is not use another good. But they not produce.
ಎಲ್ಲಾ ಕಡೆ ಪಬ್ಲಿಷ್ ಮಾಡಿದಾರೆ ಈ ತರ ಆಲ್ ಟಿಕೆಟ್ ಕಳ್ಸಿದ್ರು ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಅಂತ. ನೀವು ಬರೀ ಫೋನ್ ಅಲ್ಲೇ ವ್ಯವಹಾರ ಮಾಡ್ಕೊಂಡು ಕೂತಿದ್ರೆ ಹಿಂಗೆ ಆಗೋದು. If you not received the all ticket, you should have taken some steps.
24th examination.
ನೀವು 6 ತಿಂಗಳು ಸುಮ್ಮನೆ ಕೂತಿರೋದು ನಿಮ್ಗೆ nothing can be done now.
Still they may source be after that may be considered at least.
What is the age limit?
But
The first petition 45 ಆಗಿದೆ,
also
ಮತ್ತೆ ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ, ಇದಕ್ಕೆ ಎಲಿಜಿಬಲ್ ಇರಲಿಲ್ಲ.
because of that only we can.
No, even for this exam she was ineligible. She is 45 years.
No, not that she is eligible.
42 ಅಂತ ಹೇಳಿದ್ರೆ she is 45.
He is about 42. Also for the fighting.
6 ತಿಂಗಳಿಂದ 42, ಇವಾಗ 45.
But only
ನಿಮ್ ಕಾಸ್ಟ್ ಡೇಟ್ ನೋಡಿ, ಯಾವ ವರ್ಷದ ಎಕ್ಸಾಮ್?
19.
19, ಇವಾಗ ಬೇಡ ಬಿಡಿ, ನಾನೇನೋ 2022 ಅಂತ ಅನ್ಕೊಂಡೆ. You cannot come now in the year 2023 in respect of an exam conducted in 2019.
That is a recent we effort in 2020 presentation given in 22 level 1 to 27.
So for 3 years you kept quiet.
Exam ಆಗಿದ್ದಾವೆ. exam ಆಗಿ 6 ತಿಂಗಳ ಒಳಗೆ
ನೀವು ಈ ಗ್ರೀವೆನ್ಸ್ ಇದ್ದದ್ದು ಎಕ್ಸಾಮ್ ನಡೆಯಕ್ಕಿಂತ ಮುಂಚೆ,
please
ಅವಾಗ್ಲೂ ಏನ್ ತಗೊಳ್ಳಿಲ್ಲ. 3 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತಿದ್ದು, ಇವಾಗ
to examination papers. After examination also we approach the office for clarification and also after application because everything is
nothing can be done. ಬೇಡ, ಹೆಂಗಿದ್ರು ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಇನ್ನು ವಯಸ್ಸಿದೆ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ. ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ 34 years, that's all. ಹೋಯ್ತು. ಇನ್ನೊಬ್ರು ನೀವು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲ, ಇದು ನಿಮ್ ಪ್ರೈವೇಟ್ ಇಂಟ್ರೆಸ್ಟ್. It's difficult for me to accept that a lawyer can make this submission. ಏನೋ group D post ಆದ್ರೆ ಸರಿ, all of you are applying to become prosecutors, and if you don't know what is to be done,
very effort. Because we is argument.
Actually, the speaker,
Raichur is not outside the country.
even also they not get the phone numbers. If get the phone numbers and communicate the regularly, even also they not give proper. Our way you made out. I mean, when how you go, how get you get. Stay they give the answers.
ಅಷ್ಟೇ ಅಲ್ವಾ? That's all. The petitioners here.
Notice system and so.
ಏನ್ ಮಾಡಿದ್ರೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಇನ್ನೊಂದು ಕೇಸ್ ಅಂತ ಇರುತ್ತೆ ಅಷ್ಟೇ ಇಲ್ಲಿ. ನಿಮ್ ರಿಲೀಫ್ ಅಂತ ಏನ್ ಸಿಗಲ್ಲ. ಇವಾಗ ಅವರು ನೀವು ರೆಫರೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ, ಅವ್ರೊಂದು ಇಂಬರ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ ಅವ್ರು ನಿಮ್ಮ ಮೇಲೆ ತಪ್ಪಾಗ್ತಿದ್ದಾರೆ, which appears to be correct. To send by speed post, it was published on the internet. None of you took any steps.
Not published to different. They only they sent the speed post. I not this is the speed post.
The petitioners are candidates who had applied pursuant to the notification. Where is the notification? Dated 39/2019, by which they sought to be, by which they made a request to be appointed as assistant public prosecutor cum assistant government leader. It is their grievance that they had not received the all tickets and they were also not able to download the all tickets from the internet. It is their contention that this occurred solely due to the technical glitches in the system for which only the department was responsible. Next, by the impugned order, the director of the Department of Prosecutions has endorsed that the all tickets were sent by speed post and the same could also be downloaded from the internet. He has also observed that the petitioners have raised a plea regarding non-receipt / inability to download the all tickets 6 months after the exams were conducted. It is not in dispute that the exams were conducted in the year 2019. Were conducted in 2022, and the petitioner has kept quiet from 2019 till the exams were till 6 months after the exams were conducted to raise this plea. In my view, the director was justified in rejecting the said application on the ground that the petitioners had raised this dispute only 6 months after the exams were conducted. Since it is also admitted that the entire process is almost complete, I find no reason to entertain the petition. Petition is therefore dismissed. Marge? Or? ಏನ್ ಮಾಡ್ರಿ ಏನು Two weeks to file counter. Realist. Huh? If you don't file it after 2 weeks, I'll impose cost of 50,000 rupees. Next time, Napsi. 50,000. No. I grant you 2 weeks time on that day. If you don't file, then it will be 50,000 cost. What are you challenging annexed D? Correct, but you're an employee of PWD. PWD employee yellow back. No, you're a government employee. Where should you go? KT ತಾನೆ ಯಾರಿಗೆ ಪವರ್ ಇದೆ. ಇಟ್ಸ್ ಎ ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ ಅಫೆಕ್ಟಿಂಗ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್. ಅಲ್ಲೋಗಿ ಹಾಕಿ ಇನ್ನೇನು ನೀವು ಹೆಂಗಿರ್ ಹೋಗ್ತಿರ. And consider the petition is permitted to withdraw this writ petition with liberty to file an application for the Karnataka State Administrative Tribunal. ಏನ್ ಬೇಡ ಇಲ್ಲ ಅಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀನಿ. ನೀವು ಯಾರಿಗೆ ರೆಡಿ ಏನ್ ಅವಸರ?
Respondents have not considered the LCC certificate produced by the petitioner.
Consider the representative and pass an order. That is all.
That's instruction.
No, the prayer is only to consider his representation. Consider it and pass an order. ಅದನ್ನೇ ಬರೆದು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಅಷ್ಟೇ. ಏನ್ ಬೇಡ ಬೇಡಿ ಬನ್ನಿ. The prayer in the petition is to issue a direction to the respondents to consider the representation made by the petitioner on 21/9/2023 by the said representation. The petitioner was requesting the respondents to consider the NCC certificate of the petitioner and add the requisite incentive marks to his course and appoint him if he was eligible. Next, in my view, since the petitioner is claiming that he had produced an NCC certificate and was entitled to incentive marks, it would be appropriate to direct the respondents to consider the said request and examine the matter. The respondent shall consider the representation and pass appropriate orders in accordance with the within a period of 2 months in the date of rest of a copy of this order. ಅಲ್ಲ ಮುಂಚೆ ಕೊಡ್ಬೇಕಿತ್ತು, ಆಮೇಲೆ ಕೊಡೋಕ್ಕಲ್ಲ. ಬೇಡ ಅವ್ರು ಮಾಡ್ತಾರೆ ಬಿಡಿ, ಕನ್ಸಿಡರ್ ಮಾಡಿ. Your prayer is to consider. I directed him to consider. Whatever is there, it will be considered. ಸಿಕ್ಸ್ಟೀನ್ ಏನೋ ಒಂದು RP ಹಾಕಿದಾರಂತೆ ಈ ಆರ್ಡರ್ ಮೇಲೆ. ಸೊ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಒಟ್ಟೆ ಪೋಸ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ. They have sought for review of the order that is passed. Date ಕೊಟ್ಟಿದ್ದಾರೆ. Week's time is granted to the next.
I appear for R3 and R4, my lord.
ಇಷ್ಟೊಂದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ.
Our petitioners has to comply.
Week's time is granted to comply with. ಇದೇನ್ ಮೆಮೊ ಹಾಕಿದಾರ ನೀವು?
My lord, that is regarding the once court wanted some clarification on the 5th pay scale, 6th pay scale. ಅದನ್ನ ಮೆಮೊ ಹಾಕಿದೀವಿ ಅಷ್ಟೇ.
Application for vacating may not have been allowed. Another application for vacating stay may not. If no issue may not be declared.
ಏನ್ ಸ್ಟೇ ಕೊಟ್ರದೇನು? What is the stay granted?
Stay is granted may not in respect of the subsequent amended provision may not thereby. The requirement of passing degree may not be in respect of purpose of holding the promotion.
You're seeking for vacating the interim order grant on 16/12/2020.
16/20.
ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ನಿಮ್ ಕೇಸ್?
No. No, they're getting these all the- they are- when I enter directly, my suspicion is that they have challenged the amended provision requiring legally clarification for the purpose of promotion for the assistant review officer. Their claim is that, you know, as on the date of our appointment, this amendment was not there. We should get the benefit of whatever the rule that was prevailing then. Assuming for a moment, we not the amended rule is wrong. The decision of Supreme Court is that the vacancies that would have arisen then, on the petition would be entitled for promotion on the basis of the vacancies then, they can definitely claim, not in respect of the vacancies that would have been exceeding the direct quota.
But you are a co-employee who has that qualification and they're gonna be.
Petition, I am entering for promotion. Now, if they were to be considered for promotion or not, if the vacancies are available, then they take it. If the vacancies are not available, my submission is that as per the decision of this order, the Supreme Court, the vacancies that is available for the previous.
So what is their avenue of promotion now?
Now the promotion is that by this, not only amended to create
ಅಲ್ಲಲ್ಲ
to.
ಆಯ್ತು, amended rule ಸರಿ. By virtue of this amended rule, do they have any other avenue of promotion?
For me,
ಅವ್ರಿಗೆ
ಅವ್ರಿಗೆ ಇಲ್ಲ.
ಮತ್ತೆ ಅವ್ರಿಗೇನ್ ಮಾಡ್ಬೇಕು?
ಅವ್ರಿಗೆ for promotion, not if they have got.
ಏನು?
No requirement of promotion, not if on the
No.
basis of.
If they have alternative avenues of promotion, maybe what you say has some substance. It is not that their only avenue of promotion has been taken away. They have alternative ways of getting promoted.
Oh, you made the vacancies are immediately put there.
ಏನಂತ ಕೊಡ್ತಾರೆ? ತಿರ್ಗಾ ನೀವು ರೂಲ್ ಅಪ್ಲೈ ಮಾಡಿ ನಿಮ್ಮ ಹತ್ರ ಡಿಗ್ರಿ ಇಲ್ಲ ಆದ್ರಿಂದ ನಿಮ್ಗೆ ಕೊಡಲ್ಲ ಅಂತ ತಾನೇ ಹೇಳೋದು.
Because.
So therefore,
Loss of kindness will not.
so they will stagnate in that level forever till they retire.
No, I am not saying that. What I am.
No, that is the effect, isn't it?
No, what I am saying is that you cannot deny my promotion on the basis of requirement of. And in
But-
respect of vacancy which you are not available.
But if this rule has the effect of nullifying their chance of promotion forever,
No.
then this will have to be examined.
I don't think.
Really, if you can show me from the rules that they can get a promotion through some other post.
The requirement of assistant promotion is also assistant revenue officer. Now, if, that's what I am saying, if on the basis of the vacancies.
No, I understand the employer has the right to choose education qualification. But what should happen to the existing employees when they were appointed, when they were given
They
the,
must necessarily pass.
so at the age of 55 or 50, you want them to go get a degree and then.
What I am saying is that if they are entitled for promotion, let them take it.
Now, why can't they argue saying that this amended rules will apply only in respect to the employees appointed after this rule?
The prospective itre, prospective idru kudanu, that's what I initially submitted. If assuming for a moment that this honorable court would accept their claim that it is prospective, even then, in respect of the vacancies, which they are in excess of the quota, if they are entitled for promotion.
The quote in, this is a promotional quota ತಾನೇ ಇದು. ಒಬ್ಬೊಬ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿರಿ ಅವ್ರು.
So my submission is that, you cannot claim a right of promotion in respect of vacancy that is not available at all. My submission is that because of this honorable decision of the Honorable Supreme Court where it says that the vacancy prior to the amended rules, if built upon.
Was the Supreme Court considering a case where
Yes.
where by virtue of this amendment,
Yes.
the chances of promotions to the other employees were completely nullified? Was that a factual situation there? ಇಲ್ಲ, ನೀವ್ ಹೇಳಿ, ನೀವು if you say it is there, I'll accept it. If the Supreme Court is dealing with a case where by virtue of an amendment, the existing employees lost the right to get a promotion forever.
There are 9 members.
ನೀವು ನಾನು ಹೇಳಿದ್ ಕೇಳ್ತಿಲ್ಲ ನೀವು.
I understand, this situation is considered there, the decision would apply not of the right. There are 9 members.
The new rules, correct, ಅದೇ ಹೇಳಿದ್ದು. There can be new rules which will have to be applied as on the date of the promotion. Whatever is the existing rule, they'll have to consider. But if the new rule has the effect of nullifying a chance of promotion forever to one stream of candidates. And if that is their only source of promotion, then what should happen to them?
Now what happens is, that's what I am saying, that if the vacancies are available, you can take it.
Vacancies.
In respect of the vacancies which were available to them prior to the amendment.
So,
I myself
so if I accept your argument, a portion of this promotion could be set apart for the degree holders. Let us say there are 100 posts indicator. Maybe 10% can be given to 10 or 20. But if you do the entire 100 to them, where will they go?
You will also kindly see the amended provision.
Counter ಹಾಕಿದ್ರೆ ನೀವು who appears to the corporation. What was reason for this amendment? The amendment to the rule probably emanated from you only. Government will amend the rule, but I'm sure it started from you only. What was the proposal? What is the reason for the proposal?
Because the amendment was not there, the proposal sent by the what amendment, whatever the government have done.
Counter ಹಾಕಿಲ್ವಾ?
Those proposals were not there. In fact, regarding what the legislation by all the legislation count claims are there in a case in which the lordship are reserved for judgment, that court room is broken down. When judgment are reserved by the all these claims are there. In fact, all these claims are subsequent to the appointment of the petitioners in the instant cases. And these claims are also there.
You will have direct
They are not represented.
your direct recruits.
These claims are there, they are not reserved for judgment. And in fact, the promotion given to his claims have also been called in question in yet another petition that is also pending.
No, suppose I uphold in that petition that the quarter rule is broken down and the assignment of seniority on the basis of the interpretation by the VMP was wrong. They automatically become your seniors. This is another. The backup plan. Allah agli andre illa agli anta.
On that basis, after issuing them the notice,
Failure count. Relist on. By which time the state shall file its counter without fail. Who's on well? ಯಾರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬಹಳ ಜನ ಇದಾರೆ. ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವಿಲ್ವಾ? 19.1 she so and so states that he has entered appearance. Office to enter his name. 19.1 ತಾನೆ? ಏನಿದೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಕಾಪಿ ಕೊಟ್ಟಿದಾರಾ? ಯಾರು ಹಾಕಿರೋದು? ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್? ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿ? He stated that these no objections have been received and thus the office of objections will stand complaint. Notice this ನಾನು ಬೇರೆ ಏನು ಕೆಲಸ ಮಾಡಲ್ಲ, ಇದು ಒಂದ್ ಹಿಡ್ಕೊಂಡು ಕೂತ್ರೆ ನೀವು ಒಂದ್ ಡೇಟ್ ಬೇಕಾದ್ರೆ ತಗೊಂಡು 4:30 ಹಾಕೊಡ್ತೀನಿ, ತಗೊಳ್ಳಿ. ಲಿಸ್ಟ್ on 4:30.
My lord, I appear for the petitioner, my lord. Mr. Muttan has given me the affidavit, my lord, yesterday. Your lordship may kindly have it on 17th, my lord.
17th.
Yesterday, one day. I knew you have yesterday.
It is stated that an affidavit has ordered has been filed. Once check your instructions, the list on.
17th, your lordship may kindly have.
Memo is filed. Requesting the petition dismissal of the second segment more petition liberty.
That's your problem.
Who is opposing you? Who is opposing you? Get him. ಕರ್ಕೊಂಬಂದ್ರೆ ತಗೊಳ್ತೀನಿ. Week's time is granted to comply with the officer objections. The officer does not comply with the reason can dismiss.
So I appeal for petitioner. This is the matter on the last occasion. My learned friend on the other side had taken time that he was not well. It's a simple case where petitioners were regularized.
Edmurthy.
Yes, my
Last
lord.
time,
He's not well, my lord. I'll appear on his behalf, my lord.
yes.
Yes, my lord.
Lord, your lordship, I can see petitioners, my lord, herein are
Ready?
persons who are
My lord.
Are you ready?
Yes, my lord.
petitioners herein are all persons who are working in the respondent fire board corporation, which is a state-owned corporation. And they had earlier approached this honorable court for seeking for regularization of their services. The said writ petitions came to be allowed by page number 27, page number 32.
Na.
32, man, 32. Para 10, in 31, para 10. As stated earlier, this order round, this is the third round of litigation. Direction is issued by this court earlier on 2 occasions did not reject the claim of the petitioner, but strictly to comply the legal requirement. Petitioners are continuing continuity of service for more than
page number
26.
page number 26. Then 26. I am sorry, I told 32. 26. Para 10, my lord.
Yes.
As stated earlier, this is the third round of litigation. Direction issued by this court on earlier 2 occasions is not to reject the claim of the petitioner, strictly comply with the legal requirement. Petitioners are continuing in service for more than 15 to 20 years. From the material record, it manifests that service of the petitioners are required to be required for second response time and admitted by them. In the circumstance, a positive direction is to be issued to regularize the service of the petitioner for the reasons stated above. The petition is allowed. Response are directed to regularize the service of the petitioner by passing abrupt resolution and passing necessary approval from the government. This further direction, response shall comply with the direction within time. Matter was taken in appeal. Appeal was also dismissed. Thereafter, your lordship may kindly see page number 36. The order came to be implemented in respect of 17 persons who are the petitioner in the earlier petition. And we were also petitioners in the said petition. Said, my lord, as per Annexure C, page number 36, para 3, my lord. First para they refer to High Court order. Then para 3, ಆಡಳಿತ ಮಂಡಳಿಯು ಅನುಮೋದಿಸಿದ ಅರ್ಜಿದಾರರು ಪ್ರಸ್ತುತ ನಿಗಮದ ಉತ್ಪಾದನಾ ಕೇಂದ್ರಗಳಲ್ಲಿ ಮೇಲ್ವಿಚಾರಕರಾಗಿ ಗೌರವ ಸಂಭಾವನೆಯ ಮೇಲೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. ಪ್ರಸ್ತುತ ಆಡಳಿತ ಮಂಡಳಿಯ 17 ಮಂದಿ ಸಿಬ್ಬಂದಿ ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ದರ್ಜೆ 1 ಹುದ್ದೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ಅವರ ಸೇವೆಯನ್ನು ಕ್ರಮಬದ್ಧಗೊಳಿಸಿ ಅವರ ಹುದ್ದೆಯ ಪ್ರಸ್ತುತ ಬೇಸಿಗೆ ವೇತನ ಶ್ರೇಣಿಯು ಸೋನ್ಸೋ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಂತೆ 17 ಜನ ಸೇವೆಯನ್ನು ಕ್ರಮಬದ್ಧವಾಗಿ ಕಳೆದೆ ಅಂತ 17 ಜನದಲ್ಲಿ the petitioners herein are there, my lord. Your lordship may kindly see for factual. Srinivas Lokesh Totappa. Your lordship will find at page number 37. Totappa serial number 9. Lokesh at serial number 17. Srinivas at serial number 2. And Dasharatha at serial number 11. And Prasanna Kumar at serial number 12. Petition number 6, Mahalinge Gowda at serial number 13. And it is admitted, my lord, all these petitioners herein were there in this order of regularization. Petitioners here now are 11. But what has happened is, out of the 17 people who are regularized, 6 of them has been given a differential treatment by giving them a different pay scale, and consequently they got higher revision pay scale on that basis, and they have now, there is a parity of pay scale between the present petitioners and those persons for which we made representation as per Annexure D, page 39 on 24/8/2016. 13 ಜನ ಕಾಯಂ ನೌಕರರ ಮೂಲ ವೇತನ ಪರಿಷ್ಕರಣೆ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೇಮಕಾತಿಯಲ್ಲಿ ಒಟ್ಟು 17 ಜನರ ನೌಕರರನ್ನು ನಿಗಮಕ್ಕೆ ಕಾಯಂ ನೌಕರರಾಗಿ ನೇಮಿಸಿಕೊಂಡಿದ್ದು ಸರಿ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ 4 ಜನ ನೌಕರರಿಗೆ ಮೂಲ ವೇತನ ಪರಿಷ್ಕರಣೆಯಾಗಿ ಉಳಿದ 13 ಜನರಿಗೆ ನೌಕರಿಗೆ ತಾರತಮ್ಯವಾಗಿರುತ್ತದೆ. ಉಳಿದ 13 ಜನ ನೌಕರರು ಸಹ ನಿಗಮದ 20-25 ವರ್ಷಗಳಿಂದ ನಿಗಮದ ಹಿತದೃಷ್ಟಿಯಿಂದ ದುಡಿಯುತ್ತಾ ಬಂದಿದ್ದೇವೆ. ನಮ್ಮಗಳ ವಯೋಮಿತಿ ಮೀರುತ್ತಿದ್ದು ಪ್ರಸ್ತುತ ಬೆಲೆ ಏರಿಕೆ ದಿನಗಳಲ್ಲಿ ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿಸಿಕೊಂಡು ಜೀವನ ನಡೆಸುವುದು ಕಷ್ಟವಾಗುತ್ತೆ. ಅದನ್ನ 13 ಕಾಯಂ ನೌಕರರ ಜ್ಯೇಷ್ಠತೆ ವಿದ್ಯಾರ್ಥಿ ಪರಿಗಣಿಸಿ ಮುಂಬಡ್ತಿ ವೇತನ ಪರಿಷ್ಕರಣೆ ಮಾಡಿಕೊಡಬೇಕು ಅಂತ ಸಮಾಜಕ್ಕೆ ಪಡುತ್ತೆ. They did not do. Then we approached this honorable court, page number 40, regarding the parity of pay scale. Then your lordship may kindly see the order passed by this honorable court at page number 47.
What is the order passed thereafter?
Yes, my lord.
What is the order passed thereafter? Annexure G, na?
Annexure. Annexure G is the end. Before that, let us read, my lord, page number 1 para of earlier judgment, page number 47. Para A, 6 of the earlier round. In fact, earlier only it could have been granted, but it is like every time, so one direction, then second round. Para 6, my lord, page number 47. Having taken note of the factual aspects on record, it is not in dispute. The petitioners herein were appointed on contract basis on their appointment have been regularized by as per the directions of the High Court. It is averred in the petition that the petitioners herein have been regularized in the post of technical assistant grade 1 in the pay scales also as per Annexure C. It is the grievance of the petitioner that some of the candidates who have been appointed as per Annexure C along with the petitioner have been paid the pay scale of 9,600 so and so, Annexure D. Taking into consideration the fact that petitioner and the candidates who have been benefited with the higher pay scale have been appointed simultaneously in terms of the order dated so and so, I am of the view that Respondent Corporation shall consider the representation made by the petitioner at the earliest. However, taking into consideration the factual aspect at Annexure E, I am of the view that the petitioner be permitted to make one more representation within 2 weeks from today, and on such representation being on the corporation, in the event if the corporation that petitioners here have been discriminated, and accordingly petitioners are entitled to consequential benefits extended to the person those who have been appointed simultaneously along with this. But in another round, then one more representation enclosing the copy of the order Annexure F. Now kindly see the impugned order. Kindly see the impugned order. What are the reasons for giving certain different pay scale for 4 people? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ HM ನಾಗೇಗೌಡ ಮತ್ತು ಇತರೆ 12 ನೌಕರರು ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ 214 ನೀಡಿ 2014ರಿಂದ 2023 ವೇತನದಲ್ಲಿ ವ್ಯತ್ಯಾಸವಾಗಿರುವ ತಾರತಮ್ಯಗಳ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿ 4 ವಾರದೊಳಗೆ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವಂತ ವ್ಯವಸ್ಥೆಗಳು ವೇತನ ಮತ್ತು ಇತರ ಭತ್ಯೆಗಳನ್ನು ವಿಸ್ತರಿಸಿದ ಆದೇಶದಲ್ಲಿ ತಿಳಿಸಿದೆ. ಅದರಂತೆ ಸದರಿ ನೌಕರರು 13/3 ಮನವಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಸದರಿ ಮನೆಗಳ ನ್ಯಾಯಾಲಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶ ನೀಡಿರುತ್ತದೆ. 1. ಅನುಬಂಧ ಸಿ ಪ್ರಕಾರ 17 ಜನ ನೌಕರನ್ನು 2 ತಾಂತ್ರಿಕ ಸಹಾಯಕರು ದರ್ಜೆ 1 ಹುದ್ದೆಯಲ್ಲಿ ಸೇವೆಯನ್ನು ಕೆಲವು ಷರತ್ತು ಮತ್ತು ನಿಬಂಧನೆಗಳು ಒಳಪಟ್ಟು ವೇತನಗಳನ್ನು ವೇತನ ಕ್ರಮಬದ್ಧಗೊಳಿಸಲಾಗಿದೆ. ದಿಸ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ರೆಗ್ಯುಲೈಸೇಷನ್. ಅಪ್ ಟು ದಿಸ್ ಇಟ್ಸ್ ಓಕೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮೀಟರ್. ಕ್ರಮವಾಗಿ 30/7/14 ಕೆಲವು ನೌಕರರು ಅಂದರೆ ಗೋವಿಂದೇಗೌಡ, ರಾಜಶೇಖರ್, ಶಂಕರ್ ನಾಯಕ ಎಂಬುವರಿಗೆ ಗುರುಮೀರಿ ಪ್ರಗತಿ ಸಾಧನೆ ನಿರೀಕ್ಷೆಗಿಂತ ಹೆಚ್ಚು ತೃಪ್ತಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದ ಹಾಗೂ ಅವರ ಮನವಿಗಳ ಮೇರೆಗೆ ಹೆಚ್ಚು ಪ್ರೋತ್ಸಾಹಿಸುವ ನಿಟ್ಟಿನಲ್ಲಿ ವೇತನ ಶ್ರೇಣಿಯನ್ನು 5,800ರಿಂದ 10,000. Till today I am unheard of a person having in a particular place having worked being given a different pay scale. They say ಪ್ರೋತ್ಸಾಹಿಸುವ ನಿಟ್ಟಿನಲ್ಲಿ ಮತ್ತು ಅವರು ಮನವಿ ಸಲ್ಲಿಸಿರುವ ನಿಟ್ಟಿನಲ್ಲಿ ಅವರಿಗೆ ಬೇರೆ ಪೇ ಸ್ಕೇಲ್ 5,800 10,000 ಕೊಡಲಾಗಿದೆ. ದಿನಾಂಕ 12/10/2010 ಧನಂಜಯ್ ಅವರು ಇನ್ನೊಬ್ರು ಫೋರ್ತ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಧನಂಜಯ್ ನಿರೀಕ್ಷಿತ ಗುರಿಗಿಂತ ಹೆಚ್ಚುವರಿ ಕೆಲಸ ಸನ್ಮಾನಗೊಂಡು ಅಕ್ಟೋಬರ್ 14 5,800 10,500 ಅವರಿಗೂ ಕೊಟ್ಟು. ಸೊ ದೀಸ್ ಆರ್ ದಿ 4 persons out of 17 people who work in a particular place, and for the reasons best known they say these people have worked extraordinary, therefore they are given a different pay scale. Not only I have heard of a person being granted an additional incentive. If that to all the person, the incentive cannot be only one person, it should be all the person based on if they get. Then para 3 ಮೇಲ ದಿನಾಂಕ 27/15 ಆದೇಶದ ಪ್ರಕಾರ BH ಗೋವಿಂದೇಗೌಡ, ಧನಂಜಯ, ರಾಜಶೇಖರ್ ಮತ್ತು ಶಂಕರ್ ನಾಯಕರು ನಿಗದಿಪಡಿಸಲಾದ ವೇತನ ಶ್ರೇಣಿಯನ್ನು 6ನೇ ವೇತನ ಶ್ರೇಣಿ ಆರಂಭಿಸಬಾರದೆ 11,620. ಅಂದ್ರೆ ಏನಾಯ್ತು, ಬಿಕಾಸ್ ಆಫ್ ಹೈಯರ್ ಪೇ ಸ್ಕೇಲ್ ಗಿವನ್ ಇನ್ 2014 to these 4 candidates, in the next revision of pay scale our pay scale 11,621,000 ಗೆ ಮಾಡಿದ್ರು. 4. ತದನಂತರ ಕ್ರಮ ಸಂಖ್ಯೆ 3ರಲ್ಲಿ 11,029 6ನೇ ವೇತನ ಆಯೋಗದ ಶಿಫಾರಸಿನ ಪರಿಷ್ಕರಣೆ ವೇದಿಕೆ 21,006ರಿಂದ 42,000 ಮತ್ತೊಂದು ರಿವಿಷನ್ 42,000 ಕೊಟ್ಟದ್ದು. 5. ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ 13 ಜನ ನೌಕರಗಳು ಕೆಲಸವನ್ನು ಸಾಮಾನ್ಯ ಸೇವೆಯಲ್ಲಿ ಪರಿಗಣಿಸಿದ್ದು ಅವರಿಗೆ 1/2/15ರಿಂದ 4,800ರಿಂದ 7,275 ವೇತನ ಶ್ರೇಣಿಯನ್ನು 5,200 ಅಂದ್ರೆ ಬಿಕಾಸ್ we were in the lower pay scale of 4,800 and for us higher pay scale was not given, therefore our pay scale was revised from 4,800 to 5,200. ಮುಂದುವರಿದು ಸದರಿ 13 ಜನ ನೌಕರರು 16ರ ವಾರ್ಷಿಕ ವೇತನ ಶ್ರೇಣಿಯಾಗಿ 6ನೇ ಆಯೋಗದಿಂದ 9,600ರಿಂದ 10,800 ಸದರಿ ನೌಕರರಿಗೆ ನಮ್ಗೆ ಹಳೆ ಪೇ ಸ್ಕೇಲ್ ಅದ್ರ ಪ್ರಕಾರ ರಿವೈಸ್ ಮಾಡಿದ್ರು. ಇವರಿಗೆಲ್ಲ ಡಬಲ್ ಪೆನ್ಷನ್. ಪ್ಯಾರಾ 6 ಮೇಲ್ಕಂಡ ವೇತನ ಶ್ರೇಣಿ ನಿಗದಿಪಡಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 4 ಜನ ನೌಕರರಿಗೆ ಉತ್ಪಾದನಾ ಘಟಕದ ಪ್ರಗತಿ ಸಾಧನೆ ತೃಪ್ತಿಕರವಾಗಿದ್ದು ವಿಶೇಷ ಪ್ರಕರಣ ಹಾಗೂ ವಿಶೇಷ ವರ್ಗವೆನಿಸಲಿದೆ ಪ್ರೋತ್ಸಾಹಧನವಾಗಿ 10,000ಗಳಂತೆ 2 ಬಾರಿ ಮಂಜೂರು ಮಾಡಲಾಗಿತ್ತು. ಆದ್ದರಿಂದ ಅವರುಗಳ ಹೆಚ್ಚಿನ ವೇತನವನ್ನು ಪಡೆಯುತ್ತಿರ್ತಾರೆ. ಉಳಿದ 13 ಜನರ ಘಟಕದ ಪ್ರಗತಿ ಸಾಮಾನ್ಯವಾದ ಅವರ ಸೇವೆಯನ್ನು ವಿಶೇಷ ಪ್ರಕರಣವೆಂದು ಪರಿಗಣಿಸುವುದಿಲ್ಲ. ಮೆಲೋಡಿ ಲಾಶಿಪ್ pension, pay, increments are normal conditions of service which will depend on the cadre which we are working. My lord, you cannot fix a
rules, my lord, in this case.
Yes. What is your case?
My lord, first of all, there are no CNR rules in this matter. And the petition.
So you can do whatever you want.
No, my lord, absolutely not, my lord. My lord, first of
all of them were appointed to the same post.
My lord,
all of them are appointed to the same
post. To them as such, sir. There is no post allotted to them as such. In specific.
All of them were appointed on the same day under the same order to the same post. All of them were regularized as technical assistant 1 as per the order. Did this court permit you? Did this court permit you to pass different orders of regularization?
No, my lord, absolutely not.
So what is the reason why 4 people are excellent and the other?
No, my lord. Yes, my lord. My lord, the fact of the matter is they have been working hard and they have been giving extra services to the company because
there are no rules who is to assess whether who has worked hard or who has not worked not as hard as the others. What is the basis?
My lord, the output, my lord.
What output? They were technical assistant.
My lord, the people have been working harder than the people who have been working before. They had been suffering from a lot of other problems because of which couldn't pay the finances. However, these people were putting in extra hard work and extra hours because of which they made extra payments. And apart from that,
show me the resolution which says that the corporation, a government entity, can decide to extend the benefit of an enhanced pay scale only to a select few employees based on their performance. And who has assessed their performance? Were these people told that if you work hard or if you have met your targets, you will be granted an extraordinary pay scale?
I'll get back to you with that, my lord. I'll take this thing, the same.
No, only have to get back to me on that right now. Others don't worry about other things.
No, that's one thing they're fighting this case on, my lord, because only those people have been working hard. The others have not been working as much as needed, and moreover, they have been filing.
So how did you make that decision that they're working hard, 4 are working hard, and 13 are not working hard?
That is what was told by the client, my lord. That's what I would like to submit.
That's why they're before this court saying that your client is wrong.
No, my lord, they have their own financial grievances, my lord, because of which they're not able to pay everyone, and the one who are working hard are only the ones who are being paid. Not everyone, my lord.
It's a very, very peculiar thing I am hearing for
I
the first
agree,
time in
Amisha.
the entire service history.
You're forcing me to ensure that those 4 also don't get the pay that you have given them. Either way, you're suffering a loss. So if I were to quash that enhanced pay scale to them, maybe I'll be saving money to the corporation.
Perhaps I'll get back to you, my lord. If you could give me some time, I will get back to you by second half, my lord. I'll get back to my client and get back to you.
This is the second round of litigation, and for filing reply itself, they have taken
Either
a
you
lot of
grant
time.
the same pay scale to all the employees who are regularized pursuant to an order passed by this court,
Yes, my lord.
or you will withdraw that particular benefit given to them.
Yes, my lord.
230.
Yes, my lord. Thank you, my lord. Much obliged.
Office objections, yeah. Huh? ಕೊಡ್ತಾರಂತ ರೆಕಾರ್ಡ್ ಮಾಡ್ಲೇ ಇಲ್ಲ ಸುಮ್ಮನೆ ಹಂಗೆ ಮುಂದಕ್ಕೆ ಹಾಕಿ ಲಿಸ್ಟ್
The first matter paid process, the other two are paid process. India 20%, file amendment tradition, amendment cost.
No, but until they are served, what is the point? I'd say post after service of R4.
There is, I ensure that it is served. Maybe
Post on so and so if R4 is served by them.
please.
You want to take out and summons to R4? I think in Delhi. In addition, council is also permitted to take out notice by speed post and also person. Who's R7? ಹೇಳಿ ಓಕೆ 2 ಸಲ 3 ಸಲ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೇಸಲ್ಲಿ. ದಿಸ್ ಇಸ್ ದಟ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ ತಾನೆ. ಸಾಕಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ನಿಮ್ಗೆ. ಅದೇನ್ ತಲೆ ಕೆಡಿಸ್ಕೊಬಿಡಿ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಬೇಡ ಇವತ್ತೇ ಮಾಡಿ ಮುಗಿಸೋಣ. Next year A and T, na? I gave you time on 2 occasions only because you asked. Matter was heard on more than 1 occasion. ಅದ್ರೇನ್ ತಲೆ ಕೆಡಿಸ್ಕೊಬಿಡಿ ನೀವು, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. 16 ಬೇಡ ಆಯ್ತು, ನಾನು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ತೀನಿ, ನೀವು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ. ಮಣಂಗೇರಿ ಇವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ. ಪಾಸ್ ಅವ್ರು ಮಧ್ಯಾಹ್ನದಷ್ಟು ರೆಡಿ ಆಗಿ.
Clarification ಕೊಡ್ತೀನಿ ಅಂತ they have filed additional. That is the right, that is the right, but it is not correct.
ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಲ್ವಾ? ಅಲ್ಲ ಬಟ್ ಈಸ್ ರೈಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪೂರ್ತಿ ಆಗಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಡ್ತೀನಿ ಅಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಇಲ್ಲ ನಾನ್ ನಿಮ್ಗೆ ಹೇಳ್ತಿದ್ದೀನಿ ಅದಕ್ಕೆ
We have still norms and shit. But one thing I would like to know. The relief sort of the prayer is in the by virtue of modification amendment to the part of standing rights. These are the labor classification. In almost in all the matters, including the matter decided by your lordship, when I had a it is classified under labor code.
ನನ್ ಮುಂದೆ ಬೇಡ ಅಂತ ತಾನೇ ಹೇಳ್ತಿರೋದು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ನೀವು ಕೇಳ್ಬೇಡಿ ಅಂತ ಹೇಳ್ತಿದ್ರ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನನಗೆ ತೊಂದರೆ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಐ ಆಮ್ ಬೇಸಿಕ್ because I have heard this judgment supports for a case. They cannot seek any relief for part of standing law. When certified standing law is very much extent.
You don't want me to hear this matter, Ashtadana. You don't want me to hear this matter. You don't want me to hear this matter.
My lord, I am ready to argue the matter.
ಇದು ಹೇಳ್ತೀರಾ ಅದು ಹೇಳ್ತೀರಾ ಬರ್ಲಿ ಬಿಡಿ ಅವ್ರ ಮುಂದಿನ ಬರ್ಲಿ ಯಾಕೆ
But that is not correct.
I know it's
At the same time, my right to argue correct petition by
No, I am not saying that. You
Madam.
have the right to argue. But look at the content of the question.
like you don't want me to argue because you don't want to hear this argument because the classification is wrong, alva? You don't want to hear this matter because according to the classification is wrong, alva? ಇಲ್ಲ ಆಮೇಲೆ ತಿರ್ಗಾ ನೀವು ನಾಳೆ
This is the wrongly classified by the chief. And sorry, even my director as a office is said labor. I am not going to take.
office to examine whether the classification made by it is correct or not and post it accordingly. But this is not in good taste that you argue completely. And when I was about to pass orders, you say you are town council sought for 2 days time to make a clarification.
Right now,
ಬೇಡ ಬಿಡಿ. No, I am not interested in this case. ಬೇಡ ಬಿಡಿ.
Labor classification as a labor classification. We don't have any attachment of it. But this is not correct.
Maybe this is a lesson that I should learn, that don't express myself and keep quiet.
Not correct. I have voted direct for.
First thing is my friends should not accept the bill. When the matter is barter, they should not accept the bill.
I am not aware. It is not treated as part of it.
You asked her earlier to look at it. Three times here, I was Indian parliament, but it is not correct.
They are not the chief of something. They are ready to argue very well. They cannot make such argument.
E.P. Vivekananda.
Case may not be transferred.
Condition number 1 and 2, na?
When the earlier constitution used to be adjournment.
ಯಾಕಂದ್ರೆ ಇದೆಲ್ಲ ಬರೀ ಜಗಳ ಆಗೋ ಕೇಸ್ ಕೂಡ ಆಗ್ತಾ ಇದೆ ಇವತ್ತು. ರಿಲೀಸ್ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, 14 ಗಂಟೆ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ.
My apology is better than that.
30, 31.
In this case, the short point is that, no doubt, my lord, I have challenged seniority list in respect of my ranking, my lord, at the next year R. Indicator of personal assistant, my lord, the ranking of which is existing as on 1
ಪ್ರೇಯರ್ ಏನಾದ್ರು ಇಟ್ಬಿಡಿ ನೆಕ್ಸ್ಟ್ ಇಯರ್. ಎಸ್
next year.
ಅಲ್ಲ, you're telling a circular.
Circular as well as seniority list, next year.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಾರ?
My submission is that, if they have from their records, if they were to find that the objections which are filed for the draft list, provision list, if it is considered in the right perspective, then you should go on merits.
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗುತ್ತಾನೆ ಗೊತ್ತಾಗದು ಅದು.
One aspect of only point for consideration is whether the petitioners who have been appointed on compassion grounds, they are on par with the direct recruitment for all purposes, which they have considered from 2019 to 2019. For the first time, they changed.
ಅವ್ರನ್ನ ಕೋಟಕ್ ಹಾಕಿದಾರೆ ತಾನೆ, ಡೈರೆಕ್ಟ್ ಕೋಟಕ್ ಹಾಕಿದಾರೆ ಅವ್ರು. ನೀವು ಡಿಆರ್ ಆಲ್ ಆಫ್ ಯುವರ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಸ್. Then what is the circular that is challenged?
If appointment or compensation is considered to be on direct recruitment, which they cannot dispute and which they have accepted and they have accepted the.
But the rule is direct recruitment andre only through a competitive examination.
We are not claiming any ranking as direct recruits. Then there is a decision which I cannot tell because on merits.
File your objections.
But so far as the properties are concerned, my intact fact is considered my case. Our par with the direct recruiters cannot be denied. I mean, if they have accepted it.
Let them file objections.
No, second layer. 21 matter. Regarding the affidavit is not right. It is in respect of not witness radius.
ಏನಕ್ಕೆ why was it reduced ಅದನ್ನ ಹೇಳೇ ಇಲ್ವಲ್ಲ.
100 ಪ್ರಪೋಸಲ್ 100 ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಮಾಡಿದಾಗ 70 ಮಾತ್ರ ರಿಕ್ರೂಟ್ ಮಾಡ್ತಾರೆ. 73 73 ಗೆ ಅಪ್ರೂವಲ್ ಕಳಿಸುತ್ತೆ. Finance department has reduced for 50.
That is the reason why I wanted to find out why did you reduce? Are there any reasons at all? If the proposal was 73, for reducing it to 50, there must be some reason. ತೋರಿಸಿ ಅದನ್ನ ಅಂತ ಅಂದೆ, ಅದನ್ನ ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಹೇಳಿದ್ರೆ affidavit.
Financial department approval ಕೊಟ್ಟರು ಆಗಿದೆ.
See my order. What was the order that I had passed? The additional chief secretary shall file an affidavit as to why the posts were reduced and whether the reduction was uniform across all cadres or was left to the discretion of the commissioner who has passed the impugned order.
Finance department was given notice.
ನಾನು ಹೇಳಿದ್ದಕ್ಕೆ ಉತ್ತರ ಕೊಟ್ಟಿಲ್ಲ.
Approval ಕೊಟ್ಟರು 50 ಗೆ ಆ 50 ಪ್ರಕಾರ ಮಾಡಿ.
ಹಂಗಾರೆ ನನ್ನ ಅಫಿಡವಿಟ್ ನಾನು ಹೇಳೋ ಪ್ರಕಾರ ಆಗಲ್ವಾ?
Finance department has not approved.
ಅಲ್ಲ ಅದಾಯ್ತು, ಫೈನ್ ಅದೆಲ್ಲೂ ಹೇಳಿಲ್ಲ ನೀವು ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಪ್ರೂವ್ಡ್ ಅಂತ. ನೋಡಿ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ನೋಡಿ, ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ನೋಡಿ.
Document number 2, which they themselves have produced. In document number 2.
The specific requirement of the affidavit as to why did you reduce it? What? ಇದಕ್ಕೆ what was the reason ಅಂತ ಕೇಳಿದೆ ನಾನು. That was what he should have filed. We were aware of the fact that they had been reduced. ಏನಕ್ಕೆ ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳಿದ್ರೆ ಅದನ್ನ ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಹೇಳಿದ್ರೆ.
Finance department.
ನೀವು ಓರಲ್ ಆಗಿ ಹೇಳ್ತೀರಾ affidavit?
Finance department is an issue.
The affidavit was to be filed. The affidavit was to be filed by the additional chief secretary. ನೀವು ಅವರೇ ಇಷ್ಟು ನಾನು ಆರ್ಡರ್ ಓದಲ್ಲ ಅಂತ ಏನ್ ಹೇಳ್ಬೇಕು? Oh, and the affidavit is filed by some deputy director. ಯಾಕೆ ರವೀಂದ್ರ, you want me to ask him to be present? How can you ignore this order? I thought it was the additional chief secretary's affidavit. ಇನ್ ಇಷ್ಟೊಂದು ಕೇವಲವಾಗ ಟ್ರೀಟ್ ಮಾಡೋದ?
ಇಲ್ಲ ಈಗ ತೊಂದರೆ ಏನಾಯ್ತಂದ್ರೆ ಅವ್ರ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಇರುವಂತ
ಇಲ್ಲ, ನೀವು ಅಫಿಡವಿಟ್ ಕೊಟ್ರೆ ನಾನು ಕಣ್ಮುಚ್ಕೊಂಡು ತಗೊಂಡೆ, ಅಸ್ಯೂಮಿಂಗ್ ದಟ್ ದಿ ಅಫಿಡವಿಟ್ ವಾಸ್ ಫೈಲ್ಡ್ by the person who was directed to fill an affidavit. You have filed an affidavit of deputy director. I'll ask him to be present. This is not the way to. The order dated 12/10/2023 required the additional chief secretary, Department of Youth Empowerment and Sports, would address the communication dated 7/12/2020 to file an affidavit as to why the posts were reduced and whether the reduction was uniform across all cadres or was left to the discretion of the commissioner. The affidavit was also required to state whether the services of the fitness trainees could be utilized by all the athletes who had secured medals in their respective fields, and whether any fitness trainees had been appointed after the year 2022 in excess of the 50 posts that had been sanctioned under the communication dated 7/12/2020. Despite this specific order, an affidavit is filed by one Tippeswamy, who was working as a deputy director of Youth Empowerment and Sports. When a specific order is passed directing a specified official to sign an affidavit, it is impermissible for a subordinate of his to file an affidavit. This, in fact, amounts to disobeying the order passed on 12/10/2023. In this view of the matter, the additional chief secretary should be present before the court and shall also file an affidavit indicated in the order dated 12/10/2023. Be list on. ನೀವು ಹೇಳಿದ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ನಾನು ಫಾಲೋ ಮಾಡ್ತೀನಿ.
ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಯನ್ನು ಕೆಲಸ ಮಾಡಲೇಬೇಕು. ಅದು ಮತ್ತು ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿ ಅಂತ ಅವ್ರಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ ನಲ್ಲಿ ತಾಂತ್ರಿಕ ಸಿಬ್ಬಂದಿಗೆ ನಾವು
ಬರ್ಲಿ ಅವರು. The fact that this affidavit is filed ignoring the order sends a wrong signal to me that you are trying to. ದಿನದಿನ ಹಾಕೊಳ್ಳ.
Lords, in this matter, my lords, I appear for the AICT, my lords. Copy has not been served, my lord, despite of there being directions, my lord.
Copy ಕೊಟ್ಟಿಲ್ವಾ? ಅದೇನೋ he said that there are contradictory orders. ತಾನೆ ಆ ಕೇಸ್ ತಾನೆ?
Yes.
What happened to the division bench?
My lords, the division bench, my lords, in this matter has actually referred those matters to the three judges bench, my lord. That three judges bench has not sat so far, my lords. Perhaps because Justice Magdum was not here. Now Justice Magdum is also here, who is also part of the three judges bench, my lord. That may be constituted, my lords.
Released after 2 weeks. Released. The issues before the full bench ತಾನೆ ಅದೇನಾಗುತ್ತೋ
House.
Released after 3 weeks. Survey copy on it.
The petition of
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ? R2 is present. ಯಾಕೋ ಹಂಗಾರೆ ಅವೈಲೇಬಲ್ ವಾರೆಂಟ್ ಇಳಿಬೇಕು ನಾನು. No objections have been filed. Hence, presence of R2, please dispense with. Released one. Copy ಕೊಟ್ರಾ? Put the date. What is the impugn order? Residential certificate. You had applied for what? Anganwadi.
Next to me, get selected if I'm not.
But she was an applicant.
He's not even the applicant. He gave a complaint that I am not the resident of my particular day. And
You are not an applicant? Are you an applicant to this post? A for impleading will be considered along with the main matter. A1 for 23 for impleading will be considered along with the main matter. Who's opposing you?
Last time, last meeting, anything not the market. Specific direction, not the responding to the incident. Despite that, not on side of the not having not here. There must be despite that, there was a 5 minutes and here. This is the first notice that not there are not no fill up the vacancy also. There were 2 posts that were fill up the vacancy also, despite not having served in the copy. It was not actually run. Short point is this one. Whether a permanent employee.
Like, ಅವ್ರು ಏನಂತಾರೆ ಗೊತ್ತಾ ಈ ಸ್ಟೇಜ್ ಇರೋದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ಗೆ ನಾನು ಬರೋದ್ ಬೇಕಿರ್ಲಿಲ್ಲ ಅಂತ
Was directly very specific.
ಬಟ್ they know how to get over this.
But anything was 311 other specific direction. Despite that, repeated not. This not there will learn protection.
What?
At least meaning they are not also not considered.
What is the interim protection I can grant you if they were not
Even if not the state. Actually, a direction not taking that.
and if I grant an interim order in a case of dismissal, I will look
This time, maybe heard not. Because not been over service for 2.5 years.
post for hearing on at 4:30 on date. Good. Post in B group on date. I don't need their objections. I need their presence.
What is taking not Yes, sir.
Post in B group. Nursing council. Nursing council ತಾನೆ?
Yes.
Nursing council.
The explanation of is not eligible to go to the next rating. On the other
They're challenging annexure Q.
next year, we do work. Page 60. Page 60.
This is an order placing him an additional charge.
Additional. Important is not number one plots, of course, not your national set regarding seniority plots, I said we know. But you can't plot forcefully say, I am senior baking. No, they are not. But otherwise, plot is not eligible to go to the post meeting. Secondly, the plot,
This is the first writ petition is challenging the in-charge arrangement. Then what is the second writ petition about? What is the second writ petition about? What is it about Australia, sir? 38 points.
What he said is, the DME himself is not able to go very close to the department.
What is the prayer in 38.1? Is it the challenge to the same order? Same order.
The other petition also forgot pertains to the same.
38 and 38.1.
Challenging the order of in-charge.
Then 38.2 co-warrant. Last time I think I told you
Last time, what last time?
undertaking that you would
Affidavit filed on I have filed the affidavit of Director of Medical Education with the President of Nursing Council that within 3 months the permanent notification for the post of nurse registrar will be issued. We have already moved the file to the government seeking for the permission to move in this regard.
40% loss. That cannot work because this was already good. The thing was done earlier. It was filed. There is a direction to conclude as well as to 20. But the ineligible person is placed there. They do not want to regular appointment. They very well know in their contract they say.
No, but if they were to comply with this affidavit, your grievance is solved.
No, may not for this reason. Number one, the lords.
You don't want a regular person to be appointed.
No, I suggest this. An ineligible person about the.
ಆಮೇಲೆ ಬರ್ತೀನಿ ಅದಕ್ಕೆ. You don't want a regular selection.
That's not work out. That's not work out because.
Work out ಅಂದ್ರೆ?
Page 50.
Now, what do you mean it won't work out?
No, earlier on the Indian there was 2 years back, nothing came out. They will bring some of the contingencies later, extra time, notification, this, that, they will not bring. Page 58.
Suppose I record this undertaking and pose this matter after 3 months. And then pass an order.
Of course, it is a relief for second page for that. My suggestion is that not work out. Earlier that was there. The server directed them to conclude. They said so many things for postpone.
Suppose I were to hear you and hold that your writ does not have any merit. Then what should happen?
No, my suggestion is regarding eligibility to first law. Plus fraud. On the earlier occasion fraud, the server directed up to the fraud for an appointment.
What is the rule relating to? Is there a bar for placing a person in charge?
Even for in charge person also fraud. Or is there other persons?
Which is the rule which enables him to place them in charge?
They have what to say. They produce product next year.
What is this post for?
It goes for registrar or nursing. Register nursing. Okay, but one important aspect I wanted to bring to last.
What is a post, madam? Registrar nursing.
Register nursing. But if you ask permits people, kindly see page 53. I think that will solve the whole issue.
MSc and 10 years teaching experience.
Clinical experience, 10 years, 5 years teaching experience.
According to yes, both of them.
But you will not because therefore page 53 kindly. They won't be able to endorse. Page Director of Education issues an endorsement on the 30th of February 2021. The same context. The same context. Vishaya, Master Guest Election Year. Vishaya, Karnataka Rajya Institute of Register Rajya to 3 months on very same person. Employees markers of the medical mission ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿ ಪಕ್ಕದ ಔಷಧದಲ್ಲಿ Karnataka Constitutional Operations registrar ಶ್ರೀಗಳು ಚಿಕ್ಕವಾಗಿ ಮಾಡಬೇಕಂತ ಇವರಿಗೆ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ನಿರ್ದೇಶನಾಲಯದಿಂದ ಯಾವುದೇ ಉನ್ನತ ಹುದ್ದೆ ನೀಡಲು ಅವಕಾಶ ಬರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸರ್ವೆ ಬಗ್ಗೆ ಉನ್ನತ ಹುದ್ದೆ ನೀಡುವ ಪ್ರಶ್ನೆ ಬರುವುದಿಲ್ಲ. She clarifies that what is not eligible to hold any higher post in this department. He belongs to Kidwai. This is followed. So he has not used when other persons are eligible.
What is the rule position as far as your nursing council is concerned?
That is there.
Is there a provision for deputation? All of you are employees of the nursing council. He is an outsider. Then who are you?
I think
He is a stranger.
he brought
He is a stranger. Petitioner is a stranger. In fact, I have disputed this petition itself. How much
No, you are.
Contrary.
How can you file a writ petition in respect of a council to which you have absolutely no connection?
No, I am eligible. There is also a direction.
You are eligible for what?
No, for the very post of registrar of nursing, I am eligible to go to the post in the country.
You are-
Last time I will ask to relate to there is one more aspect is election is produced by the department. They say for us. So long as persons in the department are eligible, why do we need for others? They are not informed.
You are also outside.
No,
You are also an outsider.
I am not the outsider.
Then who are you? You are.
Same department. It's not this stuff.
The council for council, the nursing council does not admit that you are an employee of the nursing council.
I am eligible after this.
You eligible ಬೇರೆ ಪ್ರಶ್ನೆ. Are you an employee of the nursing council? Show me the appointment order. ಅವ್ರು outsider, ನೀವು outsider.
No, I am not, I belong to government health department. Whereas he is employing private institution, local body. Therefore, you must put.
How can you challenge it? How can you challenge it?
No, you must ask me whether others are considered. But in their counter, there is
Everybody-
all the cases. How
What-
will the return to consider it or notification?
No, you have the locus standi to challenge an in-charge arrangement when you are not an employee.
Charge arrangements can be questioned to us. They are also not the only paragraph.
You can challenge it. Anybody can challenge it according to.
I'm eligible, I'm home. They say-
I don't think you can maintain your writ petition.
No, my.
And who's the other petitioner in that third?
I should be.
Who's the petitioner in 38.1?
Stranger. He is a stranger. He is the employee of backlog municipal college.
Allah Shailendra, I can understand if you are. No. Locus standi ಇದೆಯಾ? Would you have locus standi to challenge? You have the locus standi to challenge it. Do both of you have the locus standi to challenge? You are one of the candidates for an in-charge arrangement? You are one of the candidates for an in-charge arrangement? Was the applications called for?
Before, they gave an answer
Or-
that they completely process. Page
Or
59.
you are not an, notification had not been issued calling for applications for an in-charge arrangement. Correct? So there is no question of you being a aspirant to this in-charge arrangement.
One of the queries,
They are 3 months ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. 3 months ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. No, that will in-charge are considered because she says 10 years and 5 years clinical experience. She says he has that, I'll examine it. But ನಿಮ್ಮಿಬ್ಬರಿಗೂ ಅಂತ locus standi ಇಲ್ಲ. I'll dismiss the petition only on that ground.
Except I mean,
I will first dismiss both of your petitions on the ground that you have no locus standi. I will record their undertaking that they will fill up the post within a period of 3 months. I'll release this on 3 months to report complaints. So that should solve your main grievance, that in-charge should not continue forever.
One more request. Page 57. it is submitted that respondent to any of them. All the others, if they are considered for that thing.
This is not a competitive case of selection for an in-charge arrangement.
Still there law requires where they should be.
Law requires a particular person to be eligible to challenge. Then, madam. New outsider. I cover around a bit. Look, stand a better. What? How do you say that she is not eligible? Bylaw? Bylaw 30. No, you are referring to bylaw? 36 is scales of pay. There are two posts of registrars, alva? First method of additional charge with Chief Accounts Officer, Chief Administrative Officer of Department of Health and Family Welfare Services, or by promotion from the cadre of Office Superintendent in Nursing Council. And this is for nurse registrar. My selection committee consisting of president, 2 members of the council, and 2 other members who are nominated by the president. President shall be chairman of the council. From when is this post vacant, madam, nurse registrar? More than?
January 20.
ಎಷ್ಟು ವರ್ಷ? ಇಲ್ಲಪ್ಪ ಆಗಿಲ್ಲ. ಯಾಕೆ?
ನರ್ಸ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಪೋಸ್ಟ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು 2022 ಅಲ್ಲಿ. ಪ್ರಪೋಸ್ಡ್ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ 2 ಪೋಸ್ಟ್ ಇದೆ. ಒಂದು ನರ್ಸ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅಡ್ಮಿನ್ who should be appointed on a deputation by the finance department in the HFW
or by promotion.
Oh, promotion really appointed.
So that post is available by for deputation or by promotion from the cadre of office superintendent in the nursing council.
ಅದು throughout the finance department ಇಂದ.
No, we are not concerned with that post now.
ಇಲ್ಲ, ಅದಕ್ಕೆ
we are concerned with nurse registrar.
ಅದು ಬೈಲಾದಲ್ಲಿ ಪ್ರಪೋಸಲ್ ಇತ್ತು. ಪ್ರಪೋಸಲ್ ಅನ್ನ ನಾವು ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಗೆ ಇದನ್ನ ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲಿಗೆ ಕಳಿಸಿದ್ವಿ ಸ್ವಾಮಿ. ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿ ಬಂದಿದ್ದು 2022 ಅಲ್ಲಿ.
91 bylaw, you are saying it was not sanctioned till 2022.
So in-charge arrangement ಇದರಲ್ಲಿ ನಡೆದಿತ್ತು 2022 ಅಲ್ಲಿ series of petitions ಎಲ್ಲ
ಅಲ್ಲ 1991 ಇಂದ ಯಾರಿದ್ರು?
various persons sir.
And this gentleman?
ಇವ್ರು ಈಗ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು
for the first time.
ಹೌದು, ಅದು ಫಸ್ಟ್ ಟೈಮ್. ಇದರಲ್ಲಿ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ he made an attempt to appoint a person on a full time basis ಸ್ವಾಮಿ. ಆ ಟೈಮ್ ಅಲ್ಲಿ series of petition ಚಾಲೆಂಜ್ ಮಾಡಿ violation of the bylaws ಎಲ್ಲಾನು.
ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿ? ಇವರೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. He had challenged.
Process of the appointment. That are allowed there is some thereafter contempt. The contempt they come forward. They withdraw their notification on the inspection.
So you want regular recruitment to be done, but until then you want to be in charge.
Yes.
You don't. You don't want the recruitment to go through. You challenge the recruitment notification. 3 months ಬೇಡ, 1 month ಅಲ್ಲಿ ಮುಗಿಸಿ.
ಸಿನಾಪ್ಸಿಸ್ ತರ ಮಾಡಿದ್ದೀವಿ.
ಸಿನಾಪ್ಸಿಸ್ ಬೇಡಿ, ಅಷ್ಟೇ ತಾನೆ.
ಕರೆಕ್ಟ್ ಡೇಟ್ಸ್ ಕೋವೆರೆಂಟ್ ಆಫ್ ಹೇಳಿರೋದ್ರಿಂದ correct dates, ಇದು qualification ಟ್ಯಾಬ್ಲೆಟ್ ಮಾಡಿ ಹಾಕ್ತೀವಿ.
ಅಲ್ಲ ಕೋವರಂಟ್ ಅವ್ರಿಗೂ ಗೊತ್ತದು ಅಷ್ಟು ಈಸಿ ಅಲ್ಲ ಅಂತ, ಬಟ್ ನೀವು this undertaking can't it be reduced from 3 months to 1 month?
Entire process ಆಗ್ಬೇಕು. ಇವಾಗ ನಾನು
When was the order passed in the contempt to complete the process?
contempt ಅಲ್ಲಿ liberty ಕೊಟ್ಟಿದ್ದು, there were lacunas in the order for calling for the notification.
When was that order passed?
22 ಅಲ್ಲಿ.
We are now in 23 November. And for 1 year, you have not taken any steps to rectify that lacuna and issue a notification.
September 2021.
Now, why should I accept this?
Place the records and whatever available in the record, I can make my submission.
So, from that particular date, when was this order passed?
22 ಅಲ್ಲಿ. ಇದು ಯಾವುದು?
Now, he's been holding this post from which time? Who has filed the affidavit now?
Director of Medical Education. He is the president, ex officio president of the nursing college.
What is this? She says as administrative approval is needed from the government.
ಸ್ವಾಮಿ, ನಾವು ನೋಟಿಫಿಕೇಶನ್ ಹೊಸದಾಗಿ ಪೋಸ್ಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಅದರಲ್ಲಿ ಹಳೆ ಬೈಲಾದಲ್ಲಿ ಇದರದ್ದು ಪೇ ಸ್ಕೇಲ್ 1900 to 3650 ಇದ್ದು FD ಅವರು ಕನ್ಕರೆನ್ಸ್ ಕೊಟ್ಟಾಗ ಪೇ ಸ್ಕೇಲ್ has been considerably increased.
How long will you take to grant that administrative approval? ಇಲ್ಲಿ ಏನೋ they require administrative approval, the government ಅಂತ ಬರೆದಿದ್ದಾರೆ. I'll have this on the 16th, on which date you will make a submission as to when you will grant the administrative approval. I expect the approval to be granted immediately. Thursday ಹಾಕೊಳ್ತೀನಿ, let us see what next. I'll dismiss all your challenge to the in-charge arrangement. But I will monitor this recruitment. That should satisfy your requirement, isn't it? ಇದೆಲ್ಲ ಕಾಂಟ್ರವರ್ಸೀಸ್ ಅಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ ಅವರು. No, but this litigation is helping him, isn't it, to continue? Therefore, let the recruitment be done. I'll monitor the recruitment. Make it note to your director that if this undertaking is disobeyed,
ನಾವು ಆಲ್ರೆಡಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀವಿ.
ಅಲ್ಲ ಒಂದು ಕೊಂಕಿಟ್ಟಿದ್ರ ಅಪ್ರೂವಲ್ ಬಂದಿಲ್ಲ ಅಂತ,
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅಪ್ರೂವಲ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಒಂದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ 3 and 3 ತಿಂಗಳು ಆಗ್ತೀರಾ ಮುಂದಕ್ಕೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ಬೇಕಾದ್ರೆ ನಾವು ಮಾಡಿಕೊಡ್ತೀವಿ. ರೆಗ್ಯುಲರ್ ಆಗಿ
Madam, for the past 1 year, nothing has happened. So you do not have credibility when you make that statement that you are very prompt in filling up that post. And you have resorted to this in-charge arrangement,
2 years.
giving rise to this litigation. So I'm not very inclined with your argument. Therefore, Warner, if this affidavit of undertaking is disobeyed, there will be a consequence. She has said there is an administrative approval required. I'll ensure that the approval is granted. 17th. ಇಲ್ಲಾಂದ್ರೆ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಬರ್ಬೇಕು. ಮಾಡ್ಲ ಆರ್ಡರ್ ಇಲ್ಲ ರಿಲಿಸ್ಟ್. What is the direction you are seeking?
Regularization of our getting interest.
No, you are asking for regulation in an interrogatory application. What is the IAFL direction?
I have further direction that there is an interim order directing that we employ the given salaries. They're not being complained, so I sought for the further direction.
Press alva. Press. What happened? Ruben had said he'll ensure that the salaries are paid. ಏನಾದ್ರು
Their allegation was that March might not pay anything. March was the salaries that transferred to the point bank till March.
After March, you said you are.
After March, we have better because after March they have not worked, but there is an interim order for us allowing them to work. So therefore, though they have not worked in us, we have the interim order to pay them. So they have already sent a proposal to us. The proposal and consideration of the POC, it should be done in us. We have already sent the proposal. And there is an order that they have to be continued services, though we have not taken work towards application. We have already sent up. One time, the 5 proposals will be implemented. I can place it on record.
We want results.
Look, our salary was limited from the regular
We just date good. The joint is filed by the state. So these state no objections. We list on. Commercial extended. ಎಲ್ಲರೂ ಇಟ್ರ ನೀವು ಕೊಟ್ಟನಲ್ರಿ ನಿಮ್ಗೆ the son of the petitioner who is present seeks for some more time to engage a counsel, relist on so and so. ನಾವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ತಿರ್ಗಾ ಟೈಮ್ ಕೊಡಲ್ಲ. 10 ವರ್ಷ ಆಡಿದ ಕೇಸ್. ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ಬಿಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡೋಗಿ ಆರ್ಡರ್ ಶೀಟ್. In matter reservation. Next ref. ನೀವು ಯಾರು ಇದರಲ್ಲಿ? No, Annex RF was a request made by you.
No, the adapting the still a state. So the state government order regularization. So they are not regularizing. So though we are eligible for regularization in C4, they are regularizing against C4. Then we offer the Honorable Court. Because this Honorable Court has given a petition to regularize, but we regularize the petitioner not from the date 49/99.
11/1990 ಇದೆಯಲ್ಲ?
They are not considered
Not
as financial. Though we are eligible, against group C.
You were regularized with effect from 11/1990 earlier
Yes,
in the group D post, but in group C post, they are saying from the date of the order.
Though we are eligible.
But you have filed this petition after how many years?
What happened that the respondent is
ನೀವೆಲ್ಲ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ರಾ? ಎಲ್ಲ ರಿಟೈರ್ ಆಗಿದ್ರಾ?
some of the processes were regularized groups in D and reorganized groups C as per election.
No, but pursuant to this order, you withdrew the writ petition.
The copies of 2043. They are given liberty to the party order.
So between the period 11/1990, Sachin, till you pass this order.
The petitioner has been observed D2 post.
ಎಲ್ಲರಿಗೂ ಸೇಮ್ ಆರ್ಡರ್ ಅಲ್ವಾ?
9/11/1995.
15/6/1992 this order is passed.
Yeah, sir, because, that is ordered in 15/6, that is 15/6/1992. The petitioner has been observed to D2 post.
With effect from which date?
With the effect from that particular date itself. That is from 15/6/1992. That is page number 30.
The page 25 alva? 25 and
The page number,
all of them are similar orders?
point of view. Page number 30 is the order. It effect from 1/2/1992.
Page?
Page 30 annexes D.
ಏನ್ ಶ್ರೀಕಂಠ?
1992 ಗೆ effect ಕೊಟ್ಟು
ಎಲ್ಲಿದೆ? ಇವ್ರು ಇನ್ನೊಂದು ಪೇಜ್ ಇಡಲ್ಲ 26 ಅದರಲ್ಲಿ
page
ಎಲ್ಲರಿಗೂ 1/2/1992.
1992 ಅಲ್ಲಿ group E post ಗೆ absorption ಮಾಡಿ.
No, 15/6/1992
Correct.
absorbed with effect from 1/12/92 as group D.
Group D.
This was
And
challenged.
after they challenge this order, that is 15/6/1992. In a repetition, the grievance that they should have been observed in C group post,
As per the government order.
government order. That is their grievance. And they should have given effect, they should have given a retrospective effect. That is what grievance in a repetition.
This was
That is WP number. Yes, 20551 of 1992, page 408 for order.
then you pass this order.
Yes, then thereafter, in the pendency of the petition, we passed this order.
One
That
minute.
is the order dated.
What was the writ petition filed against?
Yes, writ petition members as per the pleadings, I also have a look at the pleadings at page number.
This they withdrew, that is all.
Yes, I must kindly see paragraph 8, page number 8. Agreed by the
Now,
legal
where-
rights
where?
of the respondent, petitioner.
Where do you want me to-
legal rights of the petition to consider them for.
One minute, Sachin.
Yes.
They filed WP 205551-555/92 challenging the order in 15/6/92.
Yes, of 92 on the ground that they should have been observed in 2C.
No, then this was dismissed as having become infructuous. No, as infructuous.
Infractures, and there is no liberty as such. Liberty is only to claim the benefits. Can you see the order? Page 40. 443, last. It is open to the petition to seek whatever the benefits that may arise in view of the order made by the respondents.
What was the order that was made?
That is this order, that is regularization
That is absorption from D to C to.
Where is that order?
Yes, that is the very next page, page 44.
This was on 29/5/1996. This order was passed on November 16, 1995. There must be some other order that is passed. Why did you withdraw the writ petition?
First of this, I don't know the matter and the purpose of the other benefits.
This order was passed on November 16th, 1995. It says, as filed a memo, that these petitions have now become infructuous. The same shall stand disposed of as they become infructuous. However, it is made clear that it is open to the petitioners to seek whatever benefits that may arise in view of the order made by the respondents. This order could not have been made on November 16, 1995. There was some other order that was passed. And thereafter, it appears you've made one more representation on 28/2/1996. This was approved on 29/5/1996, 25/5, and therefore 29/5/1996 is granted. What is the order that you passed? Alva.
Thereafter, my lord, endorsement, they again post university to the retrospective effect. That endorsement, we have rejected.
No, once you regularize them under the GO, whatever benefits you get under the GO, you should give. If you do a mistake and absorb them in a D group post, and thereafter realizing that you change that and rectify the mistake, should that benefit not be given from the date of regularization?
Petition is filed in the year.
For the delay, there will be a consequence. But should you not act in accordance with the GO?
Government GO, what it says is that, and there is a document on record, kindly see the GO order.
There is employees.
My lord, sir.
They are 2004. They are government group C, they are number 50 isolation. They are maybe after this. In the year 2012, they are reabsorbed from group D to group C. Who are working in the same.
Sari hogalla, ನೀವು ಹೇಳೋ facts correct ಆಗಿ ಬರಲ್ಲ.
Respect of some other employees working as a group D. In the year of 2012, as per the government representation 1990, they are reabsorbed against group D post.
So why did you withdraw the writ petition? ಯಾರಿಗೋ ಕೊಟ್ಟ benefit ನೀವು ಯಾಕೆ withdraw ಮಾಡಿದ್ರಿ?
Delay act I think is one. In the year of 2012, the other employees reabsorbed. We are also opposed to this respondent authority. Respondent is not considered. That's why.
ಇಲ್ಲ, ನಿಮ್ 96 ಅಲ್ಲೇ ಕೊಟ್ರಲ್ಲ. They absorbed you in a group C post. But the request from 1199 was rejected. This you did not challenge.
Other respondents reabsorbed with effect on when they are after the group D post. And 16.
The fact that others have been reabsorbed.
Connection yesterday, kindly see page 54, effect ಯಾವತ್ತಿಂದ ಕೊಟ್ಟಿದ್ದೀವಿ. Page 54, I know all in 9/11/1985. 9/11/1985. Youth absorption 1985. 9/11/1985.
Different dates are given here for reabsorption.
Page 54.
Why did you pass this order?
It's this one. Then they have explained in the statement of objection the reason for passing section order. They also have a look at the statement of objection.
They deserve some extra consideration.
ಅದು ಒನ್ ಟೈಮ್ ಮೆಷರ್ ಅನ್ನು ಒಂದು ಸ್ಟೆಪ್ ಮಾಡಿದ್ವಿ ಅದೇ ಬೇಸಿಸ್
ನೀವೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ ಇದು. ಮತ್ತೆ ಇವ್ರಿಗೂ ಅದೇ ಬೆನಿಫಿಟ್ ಕೊಡಿ ಅಷ್ಟೇ, ವಾಟ್ ಎವರ್ ಇಸ್
ಬೆನಿಫಿಟ್ ಅಂದ್ರೆ ಅಪ್ಪ 1995 ಇಂದ ಎಫೆಕ್ಟ್ ಕೊಡ್ತೀವಿ. ಅಬ್ಸರ್ಪ್ಷನ್ 95 ಬಾಕಿದವರು 95 ದಿವಸದಿಂದ ಕೊಟ್ಟಿರೋದು. ನಿಮ್ಗೆ ಓನ್ ದಾಖಲಾತಿಯಲ್ಲಿ 95 ದಿವಸದಿಂದ ಕೊಡ್ತೀವಿ. In addition to that, we have already raised that grievance.
No, don't be technical about this. You have granted a reabsorption into Group C in respect of those employees who have been absorbed in Group D, and that has been with from a retrospective date. Page 54, you have given this benefit to others.
They have given benefit.
Give the same benefit to them.
They have given him, that same benefit is going on.
ಇವ್ರ ಹೆಸರು ಇದೆಯಾ ಅದ್ರಲ್ಲಿ 15 ಇದರಲ್ಲಿ 54 ಇದೆಯಾ ಅವ್ರ ಹೆಸರು?
Now what we are relying upon is this order. Now kindly this order was passed on.
2012.
How?
That's why ಇವ್ರು ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಬರ್ತಿರ್ಲಿಲ್ಲ. They were satisfied.
So
Because you gave this benefit to others, they are before the court.
I don't see effective date minus calendar effective date.
Nodi.
Date of giving effect.
2002, 95, 95, 98.
From that we have to regularize the sum.
See, 1995 from the date of giving effect to post within the 1995.
You said you regularize on 92 alva ಅವರು.
Absorption act 1994. D group in the C
With effect from which date? Which effect from which date?
C group again.
ಅಲ್ಲ D group. D group.
D group 1980.
1/1/1990.
Yes. D group. That is it has 1 to 1992 effective date.
ಇಲ್ಲ effective date 1/1/1990 ಅಲ್ವಾ? Where is the order of absorption?
Number 30. 15/6/1992.
1/2/92.
But the C group, D group and the C group ಹೋಗಿದ್ದು effective date that is the date of order is 9/11 1995.
ಅಲ್ಲ annexure D ಬನ್ನಿ.
Annexure D.
9/11/95. I think that is a date on which others were also.
ಇದು annexure
ಇವಾಗ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ page 54 ಅಲ್ಲಿ from 9/11/95 ಕೊಟ್ಟಿದ್ರಲ್ಲ. Extend the same benefit to them.
effective you 9/11/1995
ಅಲ್ಲ ನೀವು 1/1/1990 ಇಂದ ಕೊಡ್ಬೇಡಿ. You regularize them in this group C from the date on which they regularize that you regularize them, either 9/11/95 or any other date, that is annexure D 9/11/95. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 92.
ನಮಗೆ 92 ಕೊಡ್ತಾರೆ.
15/6. Annexure C is for Srikanta 15/6/1992. So you absorb them in group C post, therefore from 15/6/1992, not from 1/1/1990.
ಬಾಕಿ ಮಿಸ್ಟೇಕ್ ಕೊಟ್ಟಿದೆ effective date ಇಲ್ಲಿ ನೋಡಿ.
ಇಲ್ಲ ಇವ್ರು ಕೊಟ್ಟಿಲ್ವಲ್ಲ, but you have rejected their case in annexure F.
We have rejected it. We have rejected it.
You have rejected them their claim.
We found that.
No, you have rejected their claim with effect from 1/1/1990. That was the request. You rejected their claim. But in respect of other employees, you have granted them reabsorption in group C post from the date on which an order of absorption was made in respect of group D post. Annexure C ade heladu. Annexure C, look, they were retrospectively promoted in the group D post. Yes. Yes. That 9/11/95, 17/2002 are the dates on which the orders of absorption were made retrospectively in respect of group D post. Let's take this 9/11/95. The similar order of 9/11/1995 indicates that he was absorbed with effect from 92. This 1/2/1992. But their request for reabsorption in group C was accepted and they were deemed to be reabsorbed in group C post from 9/11/1995. That is the date on which their services have been regularized in a group D post. So from that date, you grant them the benefit. Don't go back to 1/1/1990. Or don't go back to 15/6/1992 or 1/2/1992. The date on which they were regularized as group D, from that particular date, give them seniority in respect of the group C post, to which you have reabsorbed them. ಬೇರೆ ಎಲ್ಲರೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೇ ತರ.
he could take absorption. ಈ ಹೇಳೋ ಪ್ರಕಾರನೇ ಮಾಡಿದ್ರು.
ಕರೆಕ್ಟ್. ಗ್ರೂಪ್ ಡಿ ಇವ್ರು ಎಲ್ಲರೂ ಒಂದೇ ತರ ಮಾಡಿದ್ರೆ that 1/2/1992 ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಆಯ್ತಾ. ಬಟ್ ದಿಸ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ on 7/11/95, 1/7/2002 on different dates. Thereafter you took a decision to reabsorb them in group C. When you reabsorbed in group C, you did not put this 1/2/1992. You said I'll give you that benefit from the date on which I regularized your services as group D. That could be 9/11/1995 or any other date. Whichever or date you pass the order for regularization as group D, from that date you consider them in the group C post.
Such a absorption itself is not published.
But you have done it.
You have done it.
Then not the first case. In other case also you have done it. Whenever you want, you will adopt. Whenever you don't want, you will.
You always think that
Then withdraw this order. Same set of employees are regularized as group D. Some employees are reabsorbed as group C, and you give them retrospective dates of absorption. But for them, you say no, I will not grant. Writ petition I will interpret that writ petition. But this is unfair.
all those things that happen. Earlier he filed a petition, he lost the battle.
He did not lose the battle. It's not very clear as to why he withdrew the writ petition. Some order was passed. There is a reason for him to withdraw. Liberty is granted him to seek for benefits of the order. But this is a new cause of action. See, this 96 order, he was satisfied. He had no problem with this. Had he not extended this benefit that he had claimed to others, the moment you pass this order, it became a new cause of action. So the earlier proceedings are or of no consequence. Delay 2012 order ಕೊಟ್ರದ್ ನೀವು. This is page 54. This is on 16/4/2012. I will mold the relief. I will hold from 16/4/2012. This order became effective and therefore they are entitled to file a writ petition. See, if I quash Annexure F, they would be entitled for absorption as group C from 1/1/1990. That is out of the question. But similarly, that you grant under 16/4/2012, you will grant it to them. Madla? Dates ಇದೆ ನಿಮ್ಗೆ ಯಾವತ್ತು ಅಪಾಯಿಂಟ್ ಆದ್ರೆ ನೀವು ಅದು ಕರೆಕ್ಟ್ ಆಗಿ
page number 52 order ಮಾಡಿದ್ವಿ. As per the government existing regulation, there is no problem to reabsorb these employees from D group to C group.
ಆದ್ರೂ ಮಾಡಿದ್ರೆ
In pursuance of the decision of the board,
ಆದ್ರೂ ಮಾಡಿದ್ರೆ
D group employees indicated for against this the condition that in case any repercussion from the government on issue, action will be initiated accordingly.
So there is no repercussion from the government.
Further, the said that reabsorbed employees to C group posts are entitled for the postal pay from the date of their duty report to the respective post. Further, their seniority is C group post shall be reckoned from the date of their duty report to their respective.
There is no repercussion from the government. What are the dates on which all of you were regularized on the same day?
The date is spelled out in page number. It is page 17. For the first petition is concerned. 15/6/1992. D group ಗೆ ಇದಾಗಿದೆ.
ಯಾವುದು annexure?
ಅದೇ page 17.
17.
ಹೌದು. ಇವರು
ಒಬ್ಬೊಬ್ಬರು ಒಂದೊಂದು ಇದೆ ಅದಕ್ಕೆ ಕೇಳ್ತಿರೋದು.
ಫಸ್ಟ್ ಪಿಟಿಷನ್ 15/6/92. ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ 20/11/79.
Now give me the dates first.
56/1992.
All of them. ಎಷ್ಟು ಜನ petitioners?
5 members.
First one.
Evening.
They have one extra. No, when was it regularized? ಎಲ್ಲರಿಗೂ the petitioners were appointed on daily wages in the year 77-78. In the year 1990, they preferred writ petitions before this court seeking for consideration of their claim for regularization, since they had completed 10 years. On 15/6/1992, orders were passed by the respondent appointing the petitioners as LR farm laborer, as farm laborer, which was a Group D post. This appointment was made with effect from 1/2/1992. The said orders for regularization were passed on the basis of the GO dated 6/8/1990. The petitioners, being dissatisfied with the order of regularization, filed WP (2055-2055/92). However, in the pendency of this writ petition, by virtue of some order passed in their favor, they withdrew the writ petition. Liberty was however reserved to them to seek for whatever benefits that would arise in their favor by virtue of the orders made by the respondent. Subsequently, the petitioners made a request to reabsorb them. Made a request to reabsorb them in a Group C post, reabsorb them as assistant, which was a Group C post. The university accepted their request for reabsorption in Group C post, subject to them withdrawing WP 2055-1-2055/1992, bracketed, which was already withdrawn. Their request for them being reabsorbed in a Group C post with effect from 1/1/1990 was, however, not granted. As the matter stood thus, it appears that the university passed an order on 16/4/2012 reabsorbing 11 D group employees as C group employees, while so reabsorbing those 11 Group D employees, the university reabsorbed them with effect from the date on which their services had been regularized as in the Group D posts. In other words, the reabsorption of the employees who had been regularized in the Group D posts was made with effect from the date on which an order of regularization had been made in their favor in respect of their Group D posts. Para? Yes. I'm saying this is 1/1/1990. I'm not asking for that. But you have reabsorbed all of them with effect from the date of regularization.
Effective date. From 9/11.
At the same date, you will give them. Whatever is the date on which you absorbed them as Group D, you will give the same benefit to them. ಅದನ್ನೇ ಕೊಟ್ರದ್ ನೀವು annexure page 54. Reabsorption of the employees in the C group posts was with effect from the date on which orders of regulation had been passed in respect of their earlier group D posts. The petitioners have thereafter preferred this writ petition, contending that they would also be entitled for being reabsorbed in the group B posts with effect from 1/1/1990 by the order dated 29/5/1996. Right, annexure F. This claim for reabsorption in C group post with effect from 1/1/1990 was not challenged, and this was not challenged. However, a prayer is made in this writ petition challenging the said request. So, since this writ petition is filed 9 years after the refusal to reabsorb them in the group C post from 1/1/1990, there is no merit in the challenge to annexure F. However, since the university has chosen to reabsorb 11 similarly placed employees into the group C post with effect from the date on which orders of regularization had been passed in their favor in respect of the group D post that they had held, it would be appropriate to direct the university to extend the similar benefit to the petitioners. The university shall accordingly consider that the petitioners were reabsorbed in the group B posts on the date on which an order had been passed in their favor, regularizing their group D posts. No benefits for this. The petitioners' pay shall be refixed notionally, and they would however not be entitled to any financial benefits. Pension ge?
Pension
their pension shall however be refixed. And they shall be paid pension, revised pension, if any, from the date of this order. Writ petition is accordingly disposed of. ಬರುತ್ತೆ ಏನಾದ್ರು ನಿಮ್ಗೆ? ಬಟ್ ಪೆನ್ಷನ್ ಇವತ್ತಿಂದ ಅಷ್ಟೇ ರಿವೈಸ್ ಆಗೋದು, ಹಳೇದು ಯಾವ್ದು ಸಿಗಲ್ಲ. ಇವತ್ತಿಂದ ತಗೊಳ್ಳಿ ಸಾಕು, ಇಷ್ಟು ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತಿದ್ರಲ್ಲ. ಅವ್ರಿಗೇನಾಗಿದೆ? ಬೇರೆ ಎಲ್ಲರೂ ಕೊಟ್ಟಿದ್ದಾರೆ. The pension shall be over refixed on the basis of the pay scale assigned to a group C post. ಯಾವ ರಿಟೈರ್ ಇದೆ ನೀವೆಲ್ಲರೂ? ಯಾವ ರಿಟೈರ್ ಆಗಿದ್ದೀರಾ? ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ರಿ. ಇವತ್ತಿಂದ ತಗೊಳ್ಳಿ ಸಾಕಂಗಾರೆ. ಅವ್ರಿಗೂ ಸುಮ್ಮನೆ ಫೈನಾನ್ಷಿಯಲ್ ಬರ್ಡನ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ, ಅವ್ರು 2012 ಅಲ್ಲಿ ಮಾಡಿದ್ರು, ನೀವು 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದಿದ್ದೀರಾ. From today, from today. Murthy or argument ಮಾಡ್ತಾರೆ. You are challenging annexure V alva.
The order of the petition authority. Effecting, allowing the petition.
On two grounds. That is, there were 7 members in the selecting committee. And what was the other ground?
They are not 70.
15 mark ಹೋದ 70 marks ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅಲ್ವಾ?
Maximum.
Your appointment was set aside in this revision.
Yes.
Please read page 139, paragraph 8. ಪ್ರತಿವಾದಿ 5 ವಾರ ಅಂದ್ರೆ ಯಾರು? The society. 8, page 139. No, please read para 8 first.
produce the report before the. So that we are secure clear path. Comparatively to the petition. That was his case.
But he has not been appointed, isn't it?
He is not appointed, that is his case. His case is that he should have been appointed because of the fact that he secured higher caste comparison. He who objects to that, said this is not the marks which was allotted. I have authenticated the list of marks, according to which the petitioner before the lordship is selected, and he should be appointed for it.
But that may not be relevant because
That is relevant for the reason. At the outset, it's important. The person who is expected, the person who is supposed to be and towards the also should be there for us. He should have been consulted towards the other reason that first he produced the document which was not authenticated towards the value department. How he said was not how he produced that document.
that is not the reason for setting aside the appointment.
I know the last paragraph of lordship can you see, whereas 9 lordship case. Consider suggestion is particular Sahaba, Madel, Maria, Mani, Madel, what has been produced by me. But words, this case should not have been considered at all. Words is my first submission. The second submission is the lordship's fairness the rules first. Yes, the authority says subject experts should have been there. And that constitution,
Murjana.
more than the that is the state committed.
Murjana.
There are regular rules, there is other things about the rules and the purpose.
Our tender consisting of the President Secretary of the Managing Committee, one subject expert,
Sir, and I'll read the rules. There are the rules, words which are made when you want the government. So, the appointment, respect of educational institutions, recruitment and terms and conditions of service of employees in private, creative, regularly and secondary institutions in 1990.
Yes.
Rule 6.
Yes.
Constitution of selection. For the purpose of recruitment, teaching and non-teaching posts, other than the post of head of institution, managing committee shall constitute a special committee consisting of. But the word should the words means consisting of. The president of the head of the managing committee or his firm, the head of the institution. An educationist or expert in the structure to which recruitment is made, selected into one. But there is slight difference towards this definition compared to what is the annexure words which is provided to the Lordship's kindly comes to the annexure 1 of the June.
Yes.
Selection authority means the selection means the selection authority consisting of president, secretary of the management.
This annexure 1 is referred to in which rule? This annexure 1.
Is annexures to the rules itself.
This is the selection authority.
Selection authority and selection is one. Lordship's kindly section says for the purpose of recruitment to teaching and not teaching posts, other than the post of head of the institution, to an institution, the managing committee shall constitute the selection committee consisting of. There is some deviation, so there's the rules. If you Lordship's kindly towards 6th clause 4, it says education is not an expert. Whereas towards the annexure says it doesn't mention about towards the education, it only says something.
Ultimately, my lord, there is some difference in those two. There is ambiguity. My submission is that what is required, both the rules are read together, is that educationist or an expert in that particular subject. Now, in this case, the committee had shown as to go all the numbers. My submission is that we had an educationist and as expert in this one.
But could it be beyond 3 people?
I would substantiate that. I read to your lordship both towards group 6 as well as towards 1, 2 is concerned. The words should be consistent. How it should be read.
Which according to you is the correct procedure that is followed, and which according to you would
I would the meaning and consisting of it, that is so much in the
just tell me according to you,
Please.
which rule provides for a larger body of a selection committee or a selection authority to be constituted. Show me that rule, sir.
No, I would show us. Words, the rules, words which are framed, says words means and consisting of. If I'm a committed person, I rely on your rules.
Saying that the rules can be amended at the interpretation by.
Not amended. Means and consisting of. Words that should be read as means and including, which is an exhaustive definition.
So does it entitle you to have a larger body?
Larger body, words, those people who are mentioned in the rules are must. In addition to that, I can have words additional persons.
Therefore, you're amending the rules.
No amending the rules. But how
So
it will be read?
if there are 3 people under the rules, one is the head of the institution,
Please.
one is the, what's his name? The president of the managing committee,
Please.
and one is an educationist or an expert to be nominated
Please.
by the governing council.
Please.
You can appoint anybody.
Not that anybody, these are must. In
No.
addition to them.
In order to have a majority view, you can have anybody that you want and
It is possible.
that I don't think is. If you show me a rule which enables them to appoint, I don't want the judgment right now. I want the rule first. I should understand the rule.
There are two rules.
This judgment does not interpret this particular rule,
No.
isn't
But
it?
it says not how.
I will come to the judgment afterwards. Under these set of rules, show me a provision under which
These two rules. It's not that towards not that there is a error bracket or whatever. Say that only 3 persons. Because there are 2 rules, there are 2 provisions in the same rules. And towards wider, so it becomes illustrative rather than towards being exhaustive. That context, my submission is that that the body, what are the constituted or including the candidate, as compared of these. And in addition to that, can have other members. As such, the objection which is raised, don't appreciate. I could have replied to that before the authority. What the authority does is that after all the arguments are when matters reserved for the orders, then written arguments are made saying that yes, there was. I never had the opportunity of even the or whatever the statements which I made, even the department had the opportunity. Because the department always took by marks but as such, we have made submission that cannot be considered. Now, if we go towards the marking is concerned, but my submission is that if it is not for 70 also, if it is later on scaled towards 50, it is not going to affect the matter much. Ultimately, the issue is who is more or who is less. As such, that will not make any difference towards so that the allotment of max towards is the very assumption. If and even otherwise, your worship I need not go to the narration and other things. It can always considered and even otherwise, the highest max towards after the findings of the authority itself. Assessment no one can be known towards the person who is also but this case should not have been considered towards the questions by the authority, but as quick objections taken. That's the reason I want to read from the order of the authority itself. That the department says this is not proper document. I object to the document. I say don't consider this. In spite of that, the authority acts on it and considers it. And it considers the case of the authority, which is not correct. Because it should have been consulted in the first instance in terms of for producing the cost of release. But as such, order we feel the submission will be there first. Highest part for first. That is towards when the objection were made, but it will be
will be dismissed.
I appear for the petitioner.
Yes.
Last occasion you asked for this matter. But annexure K is the impugned order.
Who's opposing you?
Narayan. ಅವರೇ ಇವತ್ತಿಗೆ ಹಾಕ್ಸಿದ್ರು. After a departmental inquiry, they issued second show cause notice. That also, my lord, I have replied. My lord, you will ask me kindly see the order.
Or ilvalega.
Next week afterwards.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, I will come physically, my lord, in the afternoon and I will do it, my lord, at 2:30.
Time back on
18th. ಸ್ವಾಮಿ ಹಾಗಾದ್ರೆ 18th ಗೆ ಹಾಕ್ತೀರಾ ಸ್ವಾಮಿ?
18th.
Much obliged.
Who's opposing them? Who's opposing? If they have not filed objections, can I dispose it of? Correct, but our Dr. Somshekar. ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರಲಿಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಆಮೇಲೆ ನೋಡೋಣ. Since Sri Dr. T. Somshekar is unavailable, bill is finally on.
Yes, my lord, I appear, my lord. Matter has to be heard, my lord. It may be posted for hearing at 2:30.
2:30 post for hearing ಅಂತ ಹೇಳಲ್ಲ.
Post for hearing any day next week. Other said
2 weeks time is granted to come to file statement of objections. Sorry, urgent. But 2:30 I have hearing list therefore. 24th. Same.
The state is filing the objection.
Relist.
8:30 to 10. 63.
Who's opposing you? Objections ಹಾಕಿದಾರಾ?
1998
ಏಟಿಗೆ ಹೋಗಿದ್ರಾ?
ಅದು ಮಾಡಾದ್ಮೇಲೆ ಟೆಂಪರರಿ ಎಂಪ್ಲಾಯ್ ಜಾಬ್ ಇಸ್ ನಾಟ್ ಅಪ್ರೂವ್ಡ್ ಸೆಕ್ಷನ್ 92 ಇಸ್ ನಾಟ್ ಅಪ್ರೂವ್ಡ್.
Next week. Relist.
Residential.
So GML select ಆಗಿಲ್ಲ. GM cut off ಎಷ್ಟು ಬೇಡ?
He has been selected for horizontal reservation. So the question of
First basic question. GML cut off ಎಷ್ಟಿತ್ತು? You'll ignore his physically handicapped and category. First ಅದನ್ನ ಹೇಳಿ ಫಸ್ಟ್ ಅದು ಎಷ್ಟು GM ಗೆ ಎಷ್ಟಿದೆ ಕಟ್ ಆಫ್ ಎಷ್ಟು show me that rule which says you cannot consider him in GM because I think there's a
He claims under the social reservation.
371 jail along the judgment. Only. Yes, which paragraph? Read one since special reservations in favor of physically handicapped women, etc., are horizontal reservations. The vertical is being. No, this is a special reservation for women is provided within the social reservation for scheduled caste. Read this further. The entire reservation quota will be intact and available in addition to those selected under open competition category. But the opposite principle applicable to vertical will not apply to horizontal special reservations, where a special reservation for women is provided within the social reservation for scheduled caste. The proper procedure is to first fill up the quota for scheduled caste in order of merit, and then find out the number of candidates among them who belong to the special reservation group of scheduled caste women. So, scheduled caste tiruga subcategory reservation idre seri. Now, illustration was let us illustrate with an example. Illustration was illustrate by an example. So there's a subcategory. It is in relation to that particular factual situation. They said So now according, if I accept your argument, even if a physically handicapped candidate gets a right to be selected on his own, because he applied for that, he is excluded. This judgment I will not accept as applicable to this case. The whole point here was scheduled caste category was reserved. Among them, the subcategory of women reservation should be taken care of. That is all. Here is a case where you would be otherwise eligible under the GM category. Whatever is his application, but he was even otherwise eligible under the GM category. The cutoff marks for GM was what? Did he secure more than that or less than that? Yen valuation ಹೆಂಗ್ ಬೇರೆ ಮಾಡ್ತೀರಾ? ನಿಮ್ valuation ಮಾಡೋದಕ್ಕಲ್ಲ. My whole objective was that if he is able to secure a seat on his own merit in the GM category, you cannot pigeonhole him into that physically handicapped category and say, you may have secured more. So, madam, the point is not what he claims. The point is he a meritorious candidate to be selected? Suppose he seeks for pigeonholing into one category. Even though he is eligible in the general merit category, you're going to non-suit him on that ground? That is not what is appealing to my mind. Your argument is only on the basis of his application. If you would value a physically handicapped category candidate on some other parameters and then say is eligible, that is one thing. The basic criteria is the cutoff percentage. It's not arguable. I think your argument is unfair. You're going to non-suit a physically handicapped person who is capable of securing a candidature on his own merit. Actually, by asking for the reservation, he is on a lower scale. And because of that, I am physically handicapped. So some concession is given to me. But if I am getting a seat on my own merit without that reservation, you are saying no. No. I thought the whole objective of physically handicapped reservation was to help the physically handicapped. You are penalizing a physically handicapped person because he's got more merit. So we will ignore that. How can you ignore his claim for merit when he's got better marks than the other person? The ultimate objective is the person with the most merit should be selected. Now that is defeated. Horizontal, vertical, bada principle eno yaar jaasti merit barutto avrige neevu kelsa kodbeku. Neevu vertical or horizontal andbittu meritorious student ಕಿತ್ತಾಕೋದು. ನೀವು ನಾಗೇನವ್ರೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ರಿಸರ್ವೇಶನ್ ಒಂದು ನಿಮಿಷಕ್ಕೆ ಪಕ್ಕಕ್ಕಿಡಿ. ಮೆರಿಟ್ ಅಲ್ಲಿ ಅವ್ನು ಸಿಗಂಗಿದ್ರೆ ಅವ್ನ್ ರಿಸರ್ವೇಶನ್ ಅಪ್ಲೈ ಮಾಡ್ದ ಮಾಡೋನ್ ತೊಂದರೆ ಕೊಡ್ತೀರಾ ನೀವು?
ವರ್ಟಿಕಲ್ ರಿಸರ್ವೇಶನ್ ಅಂದ್ರೆ ಜನರಲ್ ಮೆರಿಟ್ ತಗೊಂಡ್ರೆ
ನೀವು ಹಾರಿಜಾಂಟಲ್ ಬಿಟ್ಬಿಡಿ ಒಂದ್ ನಿಮಿಷಕ್ಕೆ. ಹಂಗಂದ್ರೆ ಅವ್ರ ರಿಸರ್ವೇಶನ್ ಕ್ಲೇಮ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗತ್ತೆ. ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ. ಅದು ವೆನ್ ಯು ವಾಂಟ್ ಇಟ್? 2 weeks ಅಲ್ಲ, ಇಲ್ಲ 18 ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಏಟೀನ್ತ್ ಅವ್ರು ಬರ್ಲಿ. ಅವ್ರು ನಿಮ್ದೇನಿಲ್ಲ ತಾನೆ ಅವತ್ತು, ಏನಿದ್ರೆ ಅವ್ರೇ ತಾನೆ, ಮತ್ತೆ ಬಿಡಿ, ಏನ್ ಬೇಕಿಲ್ಲ. He is bound to accept whatever you say, isn't it?
You have to buy one by it, but
the moral of the lesson is don't apply for physically handicapped. The 371J matter, this is what you people did by giving that option. The moment you gave an option, you threw them out of the entire category and pigeonholed them only into that category. You're doing the same thing for physically handicapped also. Vertical, horizontal, merit, you're disregarding merit. I will make it clear, the judgment not up.
Hello, hello. 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 Hello, 1, 2, 3, 1 testing. Hello. Repeat on the meeting start make connection receive.
Hello. 1, 2, 3. जोर बात कर रहे हैं। हेलो मेरे पत्नी का प्रॉब्लम है। इसमें आवाज आ रही तेरी नहीं जा रही प्रॉब्लम है।
Court officer. Court officer.
ಹೇಳಿ ವಿಜಯ್, ಆಯ್ತಾ ಊಟ?
ಹಾ ರೀ, ನಾನ್ ಅಪಿರ ಊಟ ಆಯ್ತು. ನಾನೇ ಅಪಿರ್ ಆಗ್ತೇನೆ ನೋಡ್ರಿ ಅಷ್ಟು ಕೇಸಿಗೆ.
ಆಯ್ತು.
ಹಾ ಅದನ್ನೇ ಹೇಳೋಣಂತೆ ಫೋನ್ ಮಾಡಿ. ನಿಮ್ದು ಊಟ ಆಯ್ತಾ?
ಆಯ್ತು ಜಸ್ಟ್.
ಹಾ ಸರಿ. ಫಸ್ಟಿಗೆ ಬಂದ್ ಧಾರವಾಡ ಬೆಂಚ?
ಹಾ ಅದೇನೆ.
ಓಕೆ.
ನಾನು ಕೊಟ್ಟಿದ್ದು ಐಡಿಯಾ
When? Yavak, sir. Counsel for the petitioner submits that the petitioner passed away in 2021. Since steps have not been taken in the prescribed time, the restoration of it.
Therefore, the 16th or 17th, complete the instruction.
2012. The last chance. Since Vikram Muni Rajgopal has ended appearance, name of Gurudev Kachimut we delete.
Notice for responding to 3 as well.
You also undertakes to give on behalf of R3.
Our bench status.
Lord, I appear for the petitioner in this case.
Yes.
My lord, I appear for the respondent.
Ah.
I had to file the objections, my lord. I have sent it. It has not been approved. My lord, another 2 or 3 weeks may be granted, my lord.
2 or 3.
My lord?
2 or 3 weeks.
3 weeks, my lord. Because some discussion they have called me and that they have to approved by the committee and all these things are there, my lord.
My lord, I am appearing on behalf of Shriyashan Ilobant.
Yes.
He is held up in other matters, sir, so can we listed on next week, madam.
Where is he? Now we are not.
Seal appeal last record. Seal number 3, Sri Veeresh Budhyal.
Lord, as per the instructions, I have informed him to appear through VC, but he told that he will appear. Viresh Budhyal will told that he would appear in the said case. Today he is available at Dharwad bench.
I'm for husband, my lords. I'm for husband, my lords.
Ready, na?
Ready, Swami.
You filed objection to the delay in filing.
Yes, my lords. Yes, my lords.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
360 days, my lords.
ಎಷ್ಟು
My lords, 360 days. There is a delay of 360 days, my lords.
How much has been passed? How much has been awarded?
25,000 each, my lords. For
How many petitioners? 2.
2, my lords.
And you are saying this is too much.
Yes, my lords. Because as per my disclosure of asset and liabilities, my lords, I earn only 2,78,000 per year, my lords.
What are you?
I'm a businessman, my lords. I'm a BA graduate. I'm running some business, my lords.
What business? Some business.
A real estate and all, my lords.
You have 300 acres.
No, my lords. It's in a dispute, my lords.
What is the dispute?
The case is pending before High Court of Mumbai, my lords. And another suit is filed by the sisters of the petitioner, my lord.
What is the share that you will get in that particular property?
Around 1/6, my lord. 1/6.
What is the total extent?
Total extent is my lords, even a petition is pending before High Court of Mumbai, wherein my father and their brothers the suit is pending, my lords, for partition and all.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಹೇಳಿ ಪೂರ್ತಿ ಒಟ್ಟು ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ? You are the only son?
I am the only son and having 5 sister, my lords.
All of them are married?
Yeah, they are married, and even 2 of my sisters have filed a petition for partition, my lords, before Ausa court, Maharashtra, my lords.
What is your share according to you?
1/6, my lords. My lords, unless and until the case pending before High Court of Mumbai, there is a joint property share, my lords, which comes around somewhere around 170 acres, my lords.
You are an MBA.
Yes, my lords. Even the respondent is holding somewhere around 48 acres of land, my lords.
On what basis does the court come to the conclusion that you're earning 50,000 rupees per month by
No,
virtue of?
my lords, it was an ex parte order, my lords. The impugn order was ex parte order, my lords.
Why did you not contest?
No, even my father was ill, my lords. They reside in Maharashtra. My business run in Gulbarga, my lords.
Why do you say it is ex parte? No, you did not appear at all.
Yes, my lords. Yes, my lords.
What is your income tax return?
I filed a memo, my lords, dated 14th of August, my lords, at page 9, my lords. ₹2,78,926, my lords.
No, what is this annexed here? B series, page 31. Gross total income is 9,97,000.
Yes, my lords.
So 10 lakhs is your declared income.
Yes, my lords. For annual income, my lords.
17-18, it is 11,87,000.
Yes, my lords.
So your income is more than 1 lakh a month, even according to your returns. And agriculture income is not shown here.
It comes to somewhere around 70,000 and all, my lords. Even
No,
yes, my lord.
This is without reference to your agriculture income, isn't it?
Yes, my lord. Yes, my lord.
So if you add agriculture income,
this is with agriculture income, my lord. This is with agriculture.
Yes, what is, where do you show the agriculture income?
What?
Agriculture income is shown only as 20,502 for 170 acres.
Yeah, it's a joint family property, my lord. Even my father and my brothers of father did not partition, my lord.
ಕರೆಕ್ಟ್ 170 ಎಕರೆಗೆ ಬರೀ 2,000 ರೂಪಾಯಿ ಬರುತ್ತೆ ತಿಂಗಳಿಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇವಾಗ ಏನಾಗಿದೆ
ರಿಟರ್ನ್ಸ್ ಫಾರ್ 170 acres.
ಇಲ್ಲ, ಇಟ್ಸ್ ಎ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ, ಮೈ ಲಾರ್ಡ್. ಅಂದ್ರೆ
1,000 ರೂಪಾಯಿ ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ ಅಷ್ಟೇ ಮನೆಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇವನ್ ಇಟ್ಸ್ ಎ ಜಾಯಿಂಟ್ ಅಂದ್ರೆ ನನ್ನ ಫಾದರ್ ಇನ್ನೂ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಅದಕ್ಕೆ ಬಟ್ ತೋರಿಸಿದ್ರಲ್ಲ, ಅಗ್ರಿಕಲ್ಚರ್ ಇನ್ಕಮ್ ಇಸ್ 20,502 at page number 37.
Yes, my lord.
120 ಎಕರೆ ಬರೀ ತಿಂಗಳಿಗೆ 2,000 ರೂಪಾಯಿ ಬರುತ್ತೆ ನಿಮ್ಗೆ ಅಷ್ಟೇ.
What do you think is appropriate?
It may be remand back, my lords. There needs to be some trial, my lords.
How much are you paying now? Have you deposited that amount?
Yes, my lord. Till now, we have paid somewhere around 9.9 lakhs and all, my lord.
After after the passing of this order?
Yes,
have you
my lord.
deposited any sums?
Lord, still 8.5 lakhs is arrears pending, my lord.
Deposited 5,50,000.
Yeah, plus 3,50,000, my lord. Totally, I have deposited. I've deposited 9 lakhs, my lord.
No, pursuant to the order that is passed by this court, by the trial court.
Yes, my lord.
June 2022. How much have you deposited after June 2022?
First, I have deposited firstly 3,50,000, my lord, and this court has asked me to pay 5,50,000, which I have paid, my lord.
How much is still due?
I have been told 8.5 lakhs. My lord.
How do you say that?
No,
Yes,
no, my lord.
No, from the date of the petition, Alva.
Yes, yes. My lord.
When was the petition filed?
Yes, sure.
This is for 2 years now.
21/9/2021, my lord.
The petition is pending for 2 years, so roughly that amount comes to 12 lakhs. And
Yes,
you
my
have paid
lord.
how much? 5.5 lakhs.
9 lakhs, my lord.
Where you paid 5.5 lakhs, and when is the other deposit?
Another deposit is 3.5 lakhs, my lord.
When?
Yes, my lord. Before it has been withdrawn, my lord. Rupees 9 lakhs has been withdrawn from.
Where do you deposit? The interim order was subject to you depositing 5.5 lakhs.
I filed a memo of calculation dated 11.
Tell me when you deposited.
It was deposited before Bijapur court, my lord. No, not Bijapur. One second. Yes, my lords. By way of DD, it was deposited by way of DD on BKGB Bank, Kalburgi, my lords. Rupees 3.5 lakhs. And rupees 5.5 lakhs was paid by DD bearing number 775224 dated 13/1/2023, my lords.
Now, where did you deposit paid 3.5 lakhs?
Before High Court, my lords. Before this court.
Because in your memo you simply state.
No, my lords. Sorry, my lords. There is another memo dated 21 July 2023, my lords. July, my lord.
Fifteen 1/2021. Now virtually 2 years.
Yes, my lord. Which?
Even according to it is 15 lakhs.
Yes, my lord.
Deposit the balance 6 lakhs then.
Okay, my lord.
As per the memo dated 21/7/2023, petitioner claims that as of that date, he is required to pay monthly maintenance, which comes to rupees 15 lakhs. He also contends that out of the said amount, he has already paid rupees 9 lakhs, and the balance of 6 lakhs is to be paid. In view of the said memo, petitioner is directed to deposit the sum of rupees 5 lakhs, 6 lakhs before the Kalburgi High Court within a period of 2 weeks from the date of receipt of a copy of this order. We list on. KT ಹೋಗ್ಬೇಕಲ್ಲ ನೀವು reserve liberty to go to KT. ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗಷ್ಟೇ. You are seeking for change of birth. You are admittedly an employee under assistant executive engineer, rural drinking water and water sanitation. ನೀವು ಅಲ್ಲೋಗಿ ಹಾಕಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇಲ್ಲ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀವಿ. ನಾನೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ, ನಿಮಗೆ ವಿಡ್ರಾ ಮಾಡ್ಬಿಡಿ. The petitioner is seeking for an amendment of his date of birth. Admittedly, the petitioner is working in the rural drinking water and water sanitation department, and he is obviously a government servant and will have to approach the Karnataka State Administrative Tribunal. In view of the above, reserve liberty to approach the Karnataka State Administrative Tribunal. This petition is dismissed. Next year, Dina. ಇಲ್ಲ ಪವರ್ ಇಲ್ಲ, KTಗೆ ಹೋಗ್ಬೇಕು, ನೀವು ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಷ್ಟಕ್ಕೆ ತಾನೆ ಬಂದಿದ್ದು. He has the power, but where should you go against that exercise of the power? No, but that order affects the government servant, isn't it? Who's in deputation? No, they have the power, but the validity of the order can be questioned where? ಅಲ್ಲೋಗಿ ಹಾಕಿ ಏನಂತಾರೆ, ಯಾಕೆ ಎಕ್ಸ್ಕೊಳ್ತಾರೆ? Admittedly, the petitioner is an assistant engineer who was appointed to the Public Works Department, and he has been deputed to the services of BBMP. Since the petitioner is an employee of the PWD, obviously any grievance that he has in respect of his condition of service would have to be necessarily agitated only before the Karnataka Administrative Tribunal. Even if the order is passed by the BPMP, reserving liberty to the petitioner to approach the case to AT. Petition is dismissed. Correct. I am not for a minute going to the merits. Allogi ಹೇಳಿ. आ गया. What is it then? Officer IML stated that IA1 by 23 has been served on the counsel for the respondent. You have subjection, it does complaint with. In covered, ಅಲ್ಲ ಅವ್ರು ಬಂದು ಒಪ್ಕೊಂಡ್ರೆ ಸರಿ ಇಲ್ಲಾಂದ್ರೆ ನಾನು post further orders on Thursday. Covered ತಾನೆ ಇದನ್ನ ತಗೊಂಡೋಗ್ಬಿಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಷ್ಟೇ ತಾನೆ. Thursday.
General choice.
Appear, my lord. Matter relating to pay scale, the other side has to answer. Discriminated.
My lord, I request for a short date, my lord, because I asked.
What has happened on 3-4 occasions. Even before filing, same thing. After filing, same thing. And again, after having made known their statements in the objection, every time if they ask for last occasion, also your lordship may remember the short for time. They got prepared. Today again time.
My lord, I did ask the concerned authority to give us the documents. They're taking some time, my lord, since there's change in management.
What management?
No, the management has changed, because of which they're not able to retrieve the documents, the performance records on basis of which they've given increment, I believe.
That you have said. What is the basis for you to come to that conclusion is what I asked you.
So the documents, my lord, there is document which is there, I believe, which is to be retrieved. I would present it before you next time, my lord. And my senior is also not available. He's hospitalized, basically. So if you could give us a short date. So humble.
If there are any rules, it should have been made available. If they say that it is under rules it is given, they should say that under these rules they were eligible for this. That having not stated so in the earlier petition also, this is second round. They should not forget that this is the second round of litigation. Earlier also they did not come out to any reply. Now also they were given opportunity to file the reply. They filed the reply. If at all they have got any authority to give any such pay scale, they should have said so. On the other hand, currently see, they have given the reasons. They don't have any authority to give a higher pay scale. What they have said in the reply is that they are performing well, they are giving. That's if there is any order. And in fact, 2 orders they have produced, annexure R1 and R2, they have given some documents. If at all they have got any documents to sustain the different pay scale given to the other, they would have produced. Now, because your lordship has asked and now posted afternoon, once again, I will produce them. It's a vague statement. I will produce some document. What document which I have not been able to produce in 2 rounds of litigation and this after filing the objection? This is just avoiding the court. That's what I can feel.
No, my lord. It's genuine concern, my lord. My senior would definitely appear, my lord.
No, I'll go by your objections and pass an order. That is all.
No, my lord. Just short date would be something which could really help me with, my lord.
No, I heard you completely, isn't it? You sought for passover to get a clarification.
Lord, they're seeking for some time, my lord. The MD is seeking for some time because he's a new MD, I believe.
So let the MD be present before the court on 17th.
Much obliged, my lord. I would say to that.
The managing director of the second respondent shall be personally present with the court on 17th, 18th. On 18th.
Much obliged, my lord. Thank you.
Number 28.
18. Saturday, no? Saturday working day. Saturday holiday working.
The working is sir, sitting
Working
is.
ನೀವು ಹೋದ್ಸಲ ಪೂರ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಇಲ್ಲ. You want to argue or not? Not on that date. ಇವತ್ತು ಮಾಡಂಗೆ ಮಾಡಿ. ಇಲ್ಲ, I'll take it as heard, file your written arguments. Heard reserved. Written arguments if any by. ನೀವು ಹಾಕಿ written arguments ಹಾಕಿ ಕೇಳ್ತೀನಿ. I'll consider the written arguments and pass orders. If you are not ready today, I'll reserve it. You file written arguments. You are challenging annexure. Huh?
ಅವ್ರ ಮನೆಯಲ್ಲಿ ಇಂಟ್ರ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ಒಂದು ಮಹಿಳೆ ಫೋಟೋ ಇದೆಯಲ್ಲ ನಾವು ನಮಗೆ ಓದಿನ ಬಗ್ಗೆ ನಮ್ಮ ಅಜ್ಜಿನವರು ಜುವೆಲ್ಸ್ ಎಲ್ಲ ಮುಂದೆ ಕರ್ಕೊಂಡು ಬಂದು ಮುಂದೆ ಎಜುಕೇಶನ್ ನಂತರ ನಮಗೆ ಅಜ್ಜಿ ನಮಗೆ ಎಜುಕೇಶನ್ ಚಿನ್ನ ಅಡ್ಮಿಷನ್ ನಾವು ಅದೇ ಎಜುಕೇಶನ್ recent deep maximum. Because the petition is concerned ಏನಾದ್ರು ಮಾಡಿ because of the instigation even she get a post graduation there is no concern. All of history will go on. In 2021, after 2 months, the petitioner is concerned.
Anything else? Paragraph? Yeah, paragraph. Six. Federation of Indian Chambers ಶುರು ಆಗುತ್ತಲ್ಲ Page number 10 alva? Doctrine of proportionality. Yes. Yes. Alva? Yes. ಏನಿದೆ?
ಪ್ರತಿ ಮಾನ್ಯ ಕನಿಷ್ಠ 15 ಬಾರಿ ತಾಲೂಕು ರೈತ ಸಂಪರ್ಕ ಕೇಂದ್ರಕ್ಕೆ
ಎಲ್ಲೋ ಕ್ಲಾಸ್ 3 ನಾ ಉಪಯೋಜನಾ ಪ್ರತಿ ಮಾಯಲ್ಲಿ ಕನಿಷ್ಠ
ಪ್ರತಿ ಮಾನ್ಯ ಕನಿಷ್ಠ 15 ಬಾರಿ ತಾಲೂಕು ರೈತ ಸಂಪರ್ಕ ಕೇಂದ್ರಗಳಿಗೆ ಆಯ್ದ ಕ್ಷೇತ್ರಗಳಿಗೆ ಭೇಟಿ ನೀಡಿ ಆತ್ಮಚರಿತ್ರೆ ಅನುಷ್ಠಾನ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಸಲಹೆ ಸೂಚನೆಗಳನ್ನು ನೀಡಿ ಕ್ಷೇತ್ರ ಸಿಬ್ಬಂದಿ ಕಾರ್ಯಗಳನ್ವಯ ಚಟುವಟಿಕಾವಾರಿ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಹೆವಾರು ತಾಲೂಕು ಮಟ್ಟದ ಎಲ್ಲ ಕ್ಷೇತ್ರ ಸಿಬ್ಬಂದಿ ಪ್ರಗತಿ ಪರಿಶೀಲನೆ ಇತ್ಯಾದಿ ಇದು ಯಾವುದು ಬರಲಿದೆ. ಅಟೆಂಡೆನ್ಸ್ ರಿಜಿಸ್ಟರ್ಗೆ ಆಫೀಸಲ್ಲಿ ಇರ್ತೀನಿ ಅಂತ ಮಾಡ್ತಿಲ್ಲ. ನಮ್ಗೆ ಡೈರಿಯಲ್ಲಿ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ, ನಾನು ಹೋಗಿದ್ದೀನಿ. ದಯವಿಟ್ಟು ಅಟೆಂಡೆನ್ಸ್ ರಿಜಿಸ್ಟರ್
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ? ಇಲ್ಲಿದೆಯಾ?
18ನೇ ತಾರೀಕು 18ನೇ ತಾರೀಕು ಇಲ್ಲಿ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ಹೋಗಿದ್ದೀನಿ ಅಂತ ಅವರೇ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ನಾನು ಹೋಗಿದ್ದೀನಿ. ಕೆಳಗಡೆ 18ನೇ ತಾರೀಕು ಆಫೀಸಲ್ಲಿ ಇದ್ದೀನಿ ಅಂತ ತೆಗಿ ಮಾಡಿ.
Where is the decision taken to not renew our contract?
ನೀವು ಡೈರಿಯಲ್ಲಿ ನಾನು ಹೋಗಿದ್ದೀನಿ ಅಂತ ಯಾವುದು ವಿಸಿಟ್ ಮಾಡಿಲ್ಲ, ಯಾವುದು ಪ್ರೋಗ್ರಾಮ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಅಗ್ರಿಕಲ್ಚರ್ ಆಫೀಸರ್ಸ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ರಿಪೋರ್ಟ್ ಡೈರಿನೇ ಬೇರೆ ಇದೆ, ಅವ್ರು ಮಾಡಿರೋ ಇದೇ ಬೇರೆ.
$75% ತಗೋಬೇಕಿತ್ತ ಅವರು? 75% ತಗೋಬೇಕಿತ್ತ?
75% ತಗೋಬೇಕು. ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಮೇಲೆ ಮಾಡ್ತೀವಿ. ಕಮ್ಮಿ ಬಂದ್ರೆ ಅವ್ರಿಗೆ 3 months ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ. ಇನ್ನೊಂದೇನು ಅವರು ಸ್ಪ್ರೆಡ್ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ ದೆನ್ ರಿಮೂವ್ ಮಾಡಿ. ನಾಟ್ ಟರ್ಮಿನೇಷನ್.
Where is the order of appointment? Page? ಈ ಅಗ್ರಿಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ₹100 ಸ್ಟ್ಯಾಂಪ್ ಮಾಡಿರೋದು. You produce that agreement that you executed service contract. ಇಲ್ಲಿದೆಯಾ?
ತಕ್ಷಣವೇ ಸೇವೆಯಿಂದ
ಕ್ಲಾಸ್ 6 ಇದೆಯಾ? ಕಳೆದ ಸಾಲಿನ ಗುತ್ತಿಗೆ ಅವಧಿಯಲ್ಲಿ ಕಾರ್ಯಪಾಲನಾ ವರದಿಯ ನೇರ ಗುತ್ತಿಗೆ ಸೇವೆಯು ತೃಪ್ತಿಕರವಾಗಿರುವುದನ್ನು ಜಂಟಿ ಕಾರ್ಯದರ್ಶಿ ನಿರ್ದೇಶಕರ ಕಾರ್ಯಕ್ಷಮತೆ ಪರಿಶೀಲನಾ ವರದಿಯ ಆಧರಿಸಿ ಆಯಾ ಸಿಬ್ಬಂದಿಯ ಸೇವೆಯನ್ನು ನಿಯಮಾನುಸಾರ ಜಿಲ್ಲಾ ಆತ್ಮಸಂಸ್ಥೆಗಳು ಮುಂದಿನ ಸೇವಾ ಅವಧಿಗೆ ಮಾತ್ರ ಸೇವೆಯನ್ನು ಪಡೆಯಲು ಹೊಸದಾಗಿ ಆದೇಶ ನೀಡುವುದು.
Next is load class. ಈ ಕುರಿತು ಮುಂಜಾಗ್ರತೆಯಲ್ಲಿ ಅಂತವರೇ ಮುಂದೆ ಇಲ್ಲ ಆದರೂ ಅವರು ಕಡ್ಡಾಯವಾಗಿ
According to your performance was not satisfactory.
misconduct ಇದೆ. misconduct
ಓಕೆನಾ? Sure. 129. Yes. ಅವರು ತೋರಿಸಿದ ಈಗ ಸುತ್ತೋಲೆಗೆ ಅನುಬಂಧ ಅಲ್ವಾ ಅದು? Yes. Huh? Yes.
ಪಡೆದಿರುವ ಶೇಕಡಾವಾರು 50ರಿಂದ 74% ಒಟ್ಟು 143 ತಮ್ಮ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಿಳಿದುಕೊಳ್ಳುವಂತೆ ಹಾಗೂ ಮುಂಬರುವ 3 ತಿಂಗಳಲ್ಲಿ 78% ಮುಗಿಸುವಂತೆ ಸೂಚಿಸಿದರು. ಏನಾದರೂ 50ರಿಂದ 70.5 ಬಂದಿದೆ. ಕಮ್ಮಿ ಬಂದಾಗ 3 ಮಂತ್ಸ್ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಇನ್ ಕೇಸ್ ನೆಕ್ಸ್ಟ್ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಲ್ಲಿ ನಾನು ಅದನ್ನು ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಅವಾಗ ಸೇವೆ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ನೋಟಿಸ್.
This is if your efficiency is not up to the mark. Misconduct ಏನಾದ್ರು ಇದೆಯಾ? ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಬೇಕು ಅನ್ಸುತ್ತೆ? ಹೌದು ಅಷ್ಟೇ ಅಲ್ವಾ? Operative portion. ಕಾಪಿ ಇದೆ ಅಲ್ವಾ ಅಟೆಂಡೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲಿ? Yes.
The SC candidate can be accommodated for 5 months. Okay, 5 months.
Yes.
That is 5 months on the loan. But based on the current development. The additional was the points. For the additional fine comes only there are backlog. Below more existing load. Existing load. I think can you see article number 1, 740.
1.5 ಅಲ್ವಾ 1.5
ಕೆಳಗಡೆ ಮೂರು ಕೆಳಗಡೆ 5 is additional erosion. 1 from first pillar. It comes 7, then after 7 then it comes more 4. ST candidate is the entire certificate fine process. Only once serial number 2 can be promoted. If it is not promoted, candidates ST candidates are not available. Then additional point is provided at point number 16.
Yes.
You know, the entire objective of providing this postal system is the additional postal system. About the government orders. About to ensure that the candidates who are ST and ST are represented in proportionate to the number of posts reserved. The recent circular states below with the around the compilation along with the memo.
Yes.
The compilation page number 27.
Yes.
So page number 27. So below there is a column number right side.
Yes. What is this?
This is the guideline circular issued by the
Frequently asked question.
state government. Subsequent to the speech of the process. Paragraph number 4, page number 27, tabular column.
Yes.
Column number 2, promotion of the persons belonging to the scheduled caste and scheduled tribes against backlog shall be continued to be accorded in accordance with the government order dated 24/6/1997. The provisions of the government order dated 1997 above will continue to operate until the existing backlog is clear. But by making any promotion thereafter in favor of the persons belonging to the scheduled caste or scheduled tribe, their representation should be limited to the extent of 50% of the total. The representation of yes, candidate were promoted below number 1, subsequent as serial number 8. And now we got the subsequently serial number 11. Yeah, very fine. Got the serial number 1. 8 are taken into consideration as what each got the falling to the SC category. Proportionate representation proportionate to the reservation provided 15% is fulfilled. And the next serial number 9, ST category. It was a backlog available. As per the 1997 circular, additional backlog has to be adjusted here. This is the backlog. Then as per that circular, it should be given as serial number 9, where it's the manual of the lane. Therefore, after my serial number 9, there are no backlog changes. Therefore, it has to be from 5 based on senior. Senior serial number 10 in the category in a HR working. The senior, therefore, it was promoted. There is no restriction. 11 and 12 are concerned. Now they are promoted, saying that they were promoted under the backlog. If it is considered, There are 12 points of roster points. If the SC candidate is promoted 3 times, and given there were 3 vacancies, and the ST candidate, 2 candidates are promoted. In the entire roster circle, the ST candidate is promoted only once. Only one chance can be given in the entire roster circle. After completion of that 32 point circle, then comes again the number. But here already when there is backlog vacancies built up, the question of again filling up backlog vacancies.
But their argument is not that this point number 8 and 9. We are not filling up a backlog vacancies. They filled up this particular points on their own seniority, not on the basis of.
They were appointed under the special recruitment right now. There were backlog vacancies. Therefore, they were recruited initially under backlog vacancies. Now, in the affidavit, they are shown as per the legal opinion. What should the remarks of the right side? They say, as per the legal opinion, dated 8/5/2015, they were promoted in the year 2001. How they could be considered as promoted under the open category, unreserved category, based on the legal opinion of 2015.
How do you say that these two were appointed regarding backlog vacancy?
That is the question.
They are disputing it. That's what they are saying. That is their whole argument.
Manohar and Miraju were appointed initially.
The promotion that was given to them, their placement at point number 8 and 9, were not on the basis of reservation or for filling up backlog vacancy. That is,
only 2 candidates.
they may be incidentally belong to.
Where there is no representation, 15 and 3%. 15 and 3% is not given, then comes backlog. If 15 and 3% is represented, the question of backlog is not already.
Now, taking an argument further.
Please.
Suppose there's a scheduled caste candidate who is eligible to get seniority on his own without benefit of the reservation. He'll have to wait till the roster point opens up according to you. That will be the extreme argument. So let's assume Munraju was getting a seniority at point number 8. But because he belongs to scheduled caste, suppose there was no backlog vacancy at all. He cannot be posted to point number 8. He has to go back to 14. 14th 16. So he can't, even though he's got merit on his own, even though by the length of his service, he can be filling up point number 8. Because he belongs to scheduled caste, he has to go down the line.
That is the point of 1997 roster points for additional providing additional roster points.
No, additional roster points.
It was modified in 2015.
No, if their context is correct, if Munraju and Manor were not promoted because of reservation, and they were promoted only because they had attained seniority by themselves, without the assistance of their reservation. Your argument is they'll still have to be filled up to only into that category.
The category once the candidates 15 and 3% is filled up, the question of backlog will not occur.
No, if that 15% is filled up under 15% quota, you're right. Suppose a SC candidate secures merit on his own and gets a seat along with the general merit. If your argument is accepted, you will have to put him in that SC category only because he belongs to scheduled caste. No, general principle is that according to you, once you are an SC, once you are an SC, you cannot come under the general merit category at all. You are stuck in that category.
As on the date of promoting Miraju and Manohar, except these 2 people who belong to the scheduled caste and scheduled caste, there were no other eligible candidates available for them. If they were promoted under unreserved category, why they were treated as unreserved category as per the legal opinion dated 8/2015?
I'm not concerned with any legal opinion. I'm concerned with settling this question on a question of law. That opinion is the opinion of the legal officer.
That is the basis for filing the request.
You satisfy me otherwise.
Yes, sir.
Your argument, if I have understood you right, is once there's a backlog vacancy, that particular candidate will have to go only to that particular point. Even if he has to come on his own, even if he is capable of coming on his own,
capable of coming on his own.
I'll give you an example. Munraju was belonging to scheduled caste. So he cannot occupy any point reserved to unreserved. Let me understand. If Munraju belongs to scheduled caste, he can never occupy any point reserved for unreserved category. He has to occupy only that point which is earmarked for scheduled caste. That is the argument.
Otherwise, it is, the main objective. The representation based on the reservation. Maintain.
Does that bar a scheduled caste candidate for being considered in the general unreserved category?
Unreserved category. If he is not, if his seniority is done.
That is what they are saying. That is why.
Then automatically he can be promoted.
That is their argument. 8 and 9 by themselves had acquired seniority and they were accordingly promoted. They were never promoted as against the backlog vacancy. Because they were promoted on their own, that backlog vacancy remained.
The backlog vacancy, automatically, by also being of 3%.
They
automatically go. Now, they are saying.
So therefore your argument is that only.
That is why I am saying, these are serial number 11 and 12. Who are junior to me? Who are junior to the petitioner, and to promote and meaning that those vacancies are backlog. As per 2015 guideline, that is government order that provides for 9 additional points to be utilized in the entire 33 points. In the earlier 1997 the circular, we provided for additional roster points at figure number 5, 11, 16. But so far as the ST is concerned, at figure number 16, it is additional roster is provided. And whereas the 1.5 with the GO date, GO of the 2015, it provided additional 9 roster points can be utilized at any time until the backlog vacancy is filled up. If that acknowledges that the GO is adopted here, then serial number 8 and 9 meets the criteria of 2015 and so. Therefore, the filling up the vacancies of the backlog vacancies of the
If your argument is extended further, when this Munraju and Manor were liable to be considered as against the backlog vacancy, then this becomes excess according to you. This 11 and 12, because that
11 and 12 it becomes excessive. Becomes excessive. If 11 and 12 were senior to me, automatically they will get.
So, but once you say those who are senior to you were promoted to point number 8 and 9, that you say that can't be done. They have to go only under the reserved points. The contradiction agata. ನೀವು ಹೇಳ್ತೀರಾ ಹನುಮಂತ ಚೈತ್ರ ನಿಮ್ಗಿಂತ senior ಇದ್ರೆ automatically they occupy. But you don't accept that promotion for Munraju and Manor.
In the senior direction, automatically they.
That is their case as regards Manor and Munraju. Yeah, or then backlog vacancy remains.
Now the entire backlog vacancy is up and closer down by and based on subsequently surplus can be shut down the section 3 and 4, providing catch up rule where the rosters additional roster points were provided to fill up the backlog vacancy. Or the reservation providing reservation to the scheduled caste and scheduled tribes in the promotion. Subsequently, an act came to be passed by the state government, which was again challenged before the Supreme Court. In the review petition, that the act was considered and the constitutional challenge was upheld. And now the entire number of seniorities will have to be reviewed in terms of section 5 of the act. You also the compilation.
Your prayer is not for that.
Promotion has to be done under this act.
Then file a fresh petition asking for such a prayer. How can you maintain this petition for some other prayer?
Now the entire promotions have to be reviewed.
If they don't do it, you know what is done. But in this petition, in which you challenge the promotion of some people, how can you expand the scope of that petition?
All the promotions are now down.
Then all you can do is withdraw the petition, ask him to read.
That has to be considered.
ಇನ್ 5 ವರ್ಷ ಇಲ್ಲೇ ಪೆಂಡಿಂಗ್ ಕೊಟ್ರೆ ಇನ್ನೊಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದ್ರೆ ತಿರ್ಗಾ ಪ್ರೇಯರ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಅವಾಗ ಇದು ಮುಗಿದ್ರೆ ಕತೆ ಆಗ್ಬಿಡ.
Now you must kindly read Act and first of appellation.
How is that applicable to your case? You are challenging the promotion of respondent number 4 and 5. Confine your argument to that you are going far beyond the writ petition.
This Act says the entire promotions from year 1978 is going to be reviewed.
So then the petition does,
Thereafter.
then the prayer does not survive for consideration.
Thereafter.
So therefore the prayer made in the petition does not survive for consideration.
Because the appointment of the promotion of the responding of the finance system is continued. So subject matter of this petition.
They don't survive for consideration because
Their promotions have to be. I mean, what happens even if
no, if according to you, that is the legal position. If the requirement of the law is that they have to review the promotions, they will review the promotions. The prayer, then therefore you may have to file a separate petition. But as far as this is concerned, this confined only to the validity of the promotions granted to R4 and R5. So I would think it's better to restrict our case.
By considering that my prayer, the subsequent act not at this present part of the apex court, since we have this act, but again, this was challenged before the apex court and not in the two cases, and Supreme Court has clarified. Therefore, that has to be considered and then my prayer is petition.
Fresh prayer, hale prayer hoidu.
Yes, section 5 of the Act of provision for all promotions in the post belonging to the state civil service shall be within the extent and according to provisions of the reservation order and other rules pertaining to method of recruitment and seniority. The appointing authority shall revise and redraw the existing seniority list to ensure the promotions are made accordingly. Provided that subsequent to such a review, wherever it is found that government servants belonging to scheduled caste and scheduled tribes were promoted against reservation and backlog vacancies in excess or contrary to the extent of reservation provided in the reservation orders shall be adjusted and limited with reference to the list of points in accordance with the reservation order issued from time to time by assigning appropriate dates of eligibility. In case if persons belonging to scheduled caste and scheduled tribes who have already been promoted against reservation or backlog vacancies in excess or contrary to the extent of reservation provisions cannot get adjusted and fitted against the roster points, they shall be continued against to be created by the concerned administrative department, presuming concurrence of finance department. Even if my petition is allowed, and also if I ask for this kind of act,
this is applicable only if a reservation is promotion is made in the reserved category. They have not been promoted in reserved category is their argument from the beginning. ನೀವು ಅದನ್ನ ಬಿಟ್ಟು ನೀವು ಮತ್ತೆ ನೀವು ಹೇಳ್ತಿರೋದು ಎಷ್ಟೇ ಒಂದ್ಸಲ ನೀವು ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಆದ್ರೆ ನೀವು ಅದರಿಂದ ಆಚೆ ಬರಕ್ಕಾಗಲ್ಲ. ನಿಮ್ನ ರೆಗ್ಯುಲರ್ ಆಗಿ ಪ್ರಮೋಟ್ ಮಾಡಿದ್ರು ನಾವು ಯು ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಅಸೈನ್ಡ್ ಫಾರ್ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಅಂಡ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್.
what is required is maintaining 53%.
Correct. They'll maintain 15 and 3% in respect of those persons who are promoted under the reserved category.
It doesn't say under reserve, promoted under reserve category.
That's why that the consequence of this argument is once you are scheduled caste, even if you secure a seat on merit, if you only do anything on your own, you still will fall under that category only. Alle barutte im argument. Pavitra case. ಅಲ್ಲ ಇವಾಗ ನನಗೆ 95% ಬರುತ್ತೆ ನನ್ನ GM category ಸಿಕ್ಬಿಡುತ್ತೆ ಸೀಟ್ though I belong to scheduled caste, but according to your argument, because I am a person of scheduled caste, I will always have to occupy that particular category only. I can't go beyond the 15%. You are pushing me into the 15%, though I have come out of it. If it is filled up from amongst the reserved category, suppose they are appointed or promoted because they belong to scheduled caste and they fill up 15%, you are right. In principle, that is the ultimate objective. 15% of the post should be reserved for scheduled caste. If they come through from scheduled caste, you are right. But if they come through general merit category, also you want to push them into the scheduled caste category.
Here, the entire promotion policy What is the main option we need to maintain? If it is less than 15 and 3%, then there have to be given priority. 15 and 3% is built up.
We'll test your argument further. 100 post ಅಲ್ಲಿ 15 scheduled caste candidates on their own merit ಬಂದ್ಬಿಡ್ತಾರೆ. They will not claim reservation. They'll apply under the GM ಅದನ್ನ ಇಟ್ಕೊಳ್ಳೋಣ. So the moment those 15 are there, 15% category is filled up. So you cannot apply reservation at all. Correct?
Question is with regard to the director.
Yeah, direct of we are concerned with the promotional with the quota. In the cadre, 15% is to be reserved to them. Some of them, let us assume, don't even apply under that category. They have not even been recruited under that category. They become entitled to promotion. 15 people are already there in that cadre on their own merit because they belong to that particular caste. It stands closed. Nobody else will be able to get inside that cadre. That is the argument, correct?
That what you are for this knowledge is with regard to the director. When it comes to the promotion, there are 100 candidates who are selected under the same notification. Let us suppose, and the top 10 candidates, out of 10 candidates, 5 persons of from among the scheduled branch and 2 persons from among the scheduled branch. Then in the entire promotion, 15 and 3 posts will have to give the scheduled caste and scheduled branch. When the representation is built up, again giving priority to the scheduled caste and scheduled branch. A selected candidate within the 100 candidates, if he is senior, in the seniority list, will get automatically promoted.
ಅದನ್ನೇ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಅವರಿಬ್ಬರಿಗೆ ಅವ್ರ ಸೀನಿಯರ್ ಮೇಲೆ ಬಂದಿದ್ದು don't count those 2 posts against the roster points, and that is their argument from the beginning.
No, well, they did not say that.
It is all from yesterday. It is their argument. These 2 people, serial number 8 and 9, are people who have been promoted on their own seniority, not on the basis of their entitlement as scheduled caste or scheduled tribe.
They were appointed under a special backlog. As on that day, as on the date of their attendance, there was no other candidate as well. Therefore, they were considered, they were appointed under the backlog vacancy, and therefore they were promoted. And the seniority was also available. Therefore, their candidates will have to be considered under the filling up under the backlog and promotional quotas. From serial number 11 and 12 concerns, it is in excess of their quota. If they were to be senior to be mellowed in the seniority, I would not have any case of all mellowed. Therefore, the promotions of respondent number 11 and 12 is concerned is contrary to the government orders and the law and the inspection. So far as the affidavit is concerned, the Lordship may kindly consider the affidavit and the legal opinion and the TBC recommendation. Lordship may kindly for that. Annexure P is the legal opinion.
Annexure?
Annexure P will not make it.
Numeric petition, yes.
There the opinion of legal and points for their consideration. Whether the reservation process is leading the excess so as to lead to see limit. Whether they say that since there is no backlog quota existing in the cadre of percent officer legal service, the quota reserved for SCSP has already been exceeded, prescribed by the government. Therefore, existing post of percent officer is required to be picked up from general category.
Whether the number of posts in a cadre is 2 or more than 2 but less than 14 reservation, this may not be applicable. Other question. Page number 87.
Yes. Yes.
State Act shall not violate constitutional mandate. What would be the test in knowing constitutional validity of the act of the state? The state is free to exercise its discretion of providing for reservation subject to limitation that there must exist compelling backwardness, inadequacy of representation in the class of vote, keeping in mind the overall administrative definition. Even if the state has reasons to make reservation, as stated above, if the input law violates any of the above substantive limits on the width of the power, the same would be liable to be set aside. Promotion of Muniraj M as assistant officer is against an unfair and not under additional point. First, may kindly now consider the date of the legal opinion. 7/5/2015. And in the affidavit, it is stated they are considered under UR as per the legal opinion dated 8/5/2015. That is subsequent to this.
Do you have the order of promotion?
All right.
Similarly, promotion of number of alligators, assistant officer is again ST additional point and not under ST additional point. Existing poster point number 2 and existing poster point number 7 are still backlog or to be built up. The say of Sri S.K. Ramegoda, Sri Baswaraj Bayani here that since there is no backlog quota existing indicator of assistant officer to be legal, and since quota reserved for ST has already been exceeded, prescribed by the government, therefore existing post of assistant officer is required to be built up from general category B, legally not accepted, vacant is not available to be built up by an unreserved candidate. Such promotions to Nilanjan and Manohar have been given under the State Act in accordance with law. The State Act need not give to the above test. Since the observations made in paragraph 163 above the complete answer to the representation of S.K. Ramegoda and Baswaraj Amige, so far as their contention that in the event of giving promotion again to a reserved candidate, then it will be 100%. Since additional point number 11 SC is to be built up by SC available candidate. Everyone is very clear. The additional poster points at serial number 7 was not available. That was again modified in the 2015. Additional point number 11 is required to utilize to create backlog vacancy. The backlog vacancy cannot be called current vacancy. It is totally segregated. There cannot be any breach of ceiling limit of 50%. The initial poster prescribed under the Department of dated showing poster prescribed by the central government of its employee. The state government has its own poster system promulgated in accordance with that. The initial poster has not been adopted by the state government. Most of the representation concerning the L-shaped poster is not speaking anything about the backlog vacancy. That cannot be adopted in the government. It cannot be out of place if it is mentioned that the government has issued a DPR dated so and so, and that which additional points have been cancelled. Reservation in promotion poster clear. The backlog post in each cycle not exceeding 9 concerning SC category and similarly reservation in promotion poster clear backlog post in each cycle not exceeding 1 concerning ST category as per government order referred about reform. The process kindly is now to the 2015 circular, the GO.
Yes.
ಕ್ರಮವಾಗಿ ಶೇಕಡ 15 ಮತ್ತು ಶೇಕಡ 3ರ ಪ್ರಮಾಣದಲ್ಲಿ ಮೀಸಲಾತಿ ಈ ಮೀಸಲಾತಿ ಜಾರಿಗೊಳಿಸಿ 33 ದಿನಗಳ ರೋಸ್ಟರ್ಗಳನ್ನು ಸಿದ್ಧಪಡಿಸಲಾಗಿದೆ. ಈ ರೋಸ್ಟರ್ಗಳನ್ನು ಮೇಲಿನ ಕ್ರಮದ ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ ಮಾರ್ಪಡಿಸಲಾಗಿದೆ. The main objective is to ಮೇಲೆ ಕ್ರಮ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ಹೋದಾಗ ದಿನಾಂಕ 1/27/2024 ಜಾರಿಗೊಳಿಸಲು ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಮೇಲೆ ಕ್ರಮ ಸಂಖ್ಯೆ 4ರಲ್ಲಿ ಹೋದಾಗ ದಿನಾಂಕ ಯಾವುದೇ ಸಂಖ್ಯೆಯ ನಿಗದಿಪಡಿಸಲಾದ ನೇಮಕಾತಿ ಏನೇ ಒಳಗೊಂಡಿದ್ದರೂ ಮುಂಗಟ್ಟಿ ಹೋದಾದಲ್ಲಿನ ಬ್ಯಾಕ್ಲಾಗ್ ಪ್ರತಿಗಳನ್ನು ದಿನಾಂಕ 23/4/2028 ಲೆಕ್ಕ ಹಾಕಿ ಭರ್ತಿ ಮಾಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿದೆ. ಕ್ರಮ ಸಂಖ್ಯೆ 5ರಲ್ಲಿ ಹೋದಾದ ದಿನಾಂಕ 16 ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ ಮುಂಬಡ್ತಿಯಲ್ಲಿನ ಬ್ಯಾಕ್ಲಾಗ್ ವಿಷಯಗಳಲ್ಲಿ ಭರ್ತಿ ಮಾಡಲು ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ನೌಕರರಿಗೆ ಹೆಚ್ಚುವರಿ ರೋಸ್ಟರ್ ಬಿಂದುಗಳನ್ನು ಸಾಧಿಸಲಾಗಿದೆ. ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಮೇಲ್ಕಂಡ ಆದೇಶಗಳನ್ನು ಜಾರಿಗೊಳಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳ ಎದುರಾಗಿ ಬಡ್ತಿ ನೀಡುವ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಅರ್ಥ ನೌಕರರು ರಿಕ್ತ ಸ್ಥಾನ ಲಭ್ಯವಿದ್ದರೂ ಈಗಿನ ಮೀಸಲಾತಿ ಪ್ರಕರಣದಂತೆ 2ನೇ ತಿಂಗಳಿನ ನಂತರ ರೋಸ್ಟರ್ 14ರವರೆಗೆ ಕಾಯಬೇಕಾಗುತ್ತದೆ. ಅದೇ ರೀತಿ ಜಾತಿಗೆ ಸೇರಿದ ಅರ್ಹ ನೌಕರರು ರೋಸ್ಟರ್ ವರ್ತುಲದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಹೆಚ್ಚುವರಿ ರೋಸ್ಟರ್ ಬಿಂದುಗಳು ಲಭ್ಯವಾಗುವವರೆಗೂ ಕಾಯಬೇಕಾಗಿರುವುದರಿಂದ ಈ ವರ್ಗದ ನೌಕರರಿಗೆ ಕೆಲವು ಮೇನ್ ಆಬ್ಜೆಕ್ಟಿವ್ ಪ್ರೊವೈಡ್ ದಿಸ್ ನೋಟಿಫಿಕೇಶನ್ ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಮೇಲ್ಕಂಡ ಆದೇಶ ಜಾರಿಗೊಳಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳ ಎದುರಾಗಿ ಭರ್ತಿ ನೀಡುವ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಅರ್ಹ ನೌಕರರು ರಿಕ್ತ ಸ್ಥಾನ ಲಭ್ಯವಿದ್ದರೂ ಈಗಿನ ಮೀಸಲಾತಿ ವರ್ತುಲದಂತೆ 2ನೇ ಬಿಂದುವಿನ ನಂತರ ರೋಸ್ಟರ್ ಬಿಂದು 14ರವರೆಗೂ ಕಾಯಬೇಕಾಗಿರುತ್ತದೆ. ಅದೇ ರೀತಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಅರ್ಹ ನೌಕರರು ರೋಸ್ಟರ್ ವರ್ತುಲದಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಲಭ್ಯವಾಗುವವರೆಗೂ ಕಾಯಬೇಕಾಗಿರುವುದರಿಂದ ಈ ವರ್ಗದ ನೌಕರರಿಗೆ ಮುಂಬಡ್ತಿಯಲ್ಲಿ ವಿಳಂಬ ಹಾಗೂ ತಾರತಮ್ಯ ಉಂಟಾಗುತ್ತಿದೆ ಎಂದು ತಿಳಿಸಿ ಅದನ್ನು ಪರಿಹರಿಸುವ ತಿದ್ದುಪಡಿಗೆ ಆದೇಶ ಹೊರಡಿಸುವಂತೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಬಗ್ಗೆ ಸರ್ಕಾರ ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳಿಗೆ ಎದುರಾಗಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡಗಳಿಗೆ ಮುಂಬಡ್ತಿ ನೀಡುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಕೆಳಗಡೆ ದಿನಾಂಕ 16 ಸರ್ಕಾರಿ ಆದೇಶ ಪರಿಶಿಷ್ಟ ಜಾತಿ ನೌಕರರಿಗೆ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಹೆಚ್ಚುವರಿ ರೋಸ್ಟರ್ ಬಿಂದುಗಳಾದ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ನೌಕರರಿಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಹೆಚ್ಚುವರಿ ರೋಸ್ಟರ್ ಬಿಂದು 16 ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ನೌಕರರಿಗೆ ಬಡ್ತಿಯನ್ನು ಮೀಸಲಾತಿ ಬಡ್ತಿಯಲ್ಲಿನ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳನ್ನು ತುಂಬಲು 33 ಬಿಂದುಗಳ ರೋಸ್ಟರ್ ಪತ್ರದಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಕಾರ್ಯವಿಧಾನಗಳನ್ನು ಆದೇಶ. ಈ ಆದೇಶ ಹೊರಡಿಸಲಾದ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಹೆಚ್ಚುವರಿ ಮೀಸಲಾತಿ ಬಿಂದುಗಳನ್ನು ಈಗಾಗಲೇ ಉಪಯೋಗಿಸಿ ಪೂರ್ಣಗೊಳ್ಳದೇ ಇದ್ದಲ್ಲಿ ಆ ರೋಸ್ಟರ್ ಪತ್ರದಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಮೀಸಲಾತಿ ಬಿಂದುಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಈಗ ನಿಗದಿಪಡಿಸಿದ ಗರಿಷ್ಠ ಸಂಖ್ಯೆ 9ಕ್ಕೆ ಮಿತಿಗೊಳಿಸುವುದು. ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳ ಕೊರತೆಯು ಅದೇ ರೋಸ್ಟರ್ ಪತ್ರದಲ್ಲಿ ಕಡಿಮೆಯಿದ್ದರೆ ಮುಂದಿನ ರೋಸ್ಟರ್ ಪತ್ರದಲ್ಲಿಯೂ ಇದೇ ಪದ್ಧತಿ ಅಂತಹ ಕೊರತೆಯನ್ನು ಮೇಲೆ ವಿವರಿಸಿರುವ ಪದ್ಧತಿಯನ್ನು ಸರಿಪಡಿಸುತ್ತದೆ. Only so far as providing additional roster points at 5, 9, 11 was withdrawn, modified in this circular. Other instructions contained in Melor 1997 circular. That is
No, the roster point was 1, 7, 14, 21, 27. That continued. Then the second column. ಪರಿಶಿಷ್ಟ ಜಾತಿ ನೌಕರಿಗೆ ಬಡ್ತಿಯಲ್ಲಿ ಮೀಸಲಾತಿ ಒದಗಿಸಲು 33 ರೋಸ್ಟರ್ ಬಿಂದುಗಳ ವರ್ತುಲದಲ್ಲಿ ಹಾಲಿ ನಿಗದಿಪಡಿಸಿರುವ 1, 7, 14, 21, 27ನೇ ಬಿಂದುಗಳ ಜೊತೆಗೆ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳನ್ನು ತುಂಬುವ ಸಂದರ್ಭದಲ್ಲಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗೆ ಸೀಮಿತಗೊಳಿಸಿ ಅರ್ಹ ನೌಕರ ಲಭ್ಯತೆಯನ್ನು ಅನುಸರಿಸಿ ಒಂದು ರೋಸ್ಟರ್ ವರ್ತುಲದಲ್ಲಿ ಗರಿಷ್ಠ 9 ಹೆಚ್ಚುವರಿ ಬಿಂದುಗಳನ್ನು ಪರಿಗಣಿಸಿ ಬಡ್ತಿ ನೀಡುವಂತೆ ಮಾರ್ಪಡಿಸಲಾಗಿದೆ. So you don't have to wait till that particular point opens up. You can appoint them by considering them as against that additional points. Yes. In backlog, that's the whole. Unless you are able to establish that those two people were appointed against backlog vacancy, then.
The main objective, the way I am thinking of the main objective of 33-point roster system is to maintain 15 and 3% reservation.
Even if they.
Once that is fulfilled. Once that is fulfilled.
If serial number 8 and 9 were promoted under the reserved category by virtue of their reservation, whatever you say is right.
But they were appointed without.
That is of no consequence. Where are they promoted because they belong to scheduled caste, scheduled tribe, or are they promoted because they have attained seniority? If the answer to the second question is yes, then no question of backlog vacancy.
That is considered the 100% reservation. The entire, there are only,
You get back to the same point. Once your Boris,
supposed to be given the SC and ST.
your point is, your point is that, your point is that once you belong to scheduled caste, irrespective of the manner in which you are recruited, you will always be pigeonholed into that particular category. You can never come out of it.
Not in there. Example, an 100 candidate was selected. 15 and 3% separately selected under the reserve category. There will be many other persons belonging to SC and ST who are more meritorious. Will also be among the 100 candidates.
Suppose those people are promoted to the next cadre by virtue of them being general merit category. According to you, in that promoted category, since they belong to scheduled caste, they can be set as allocated to the 15% quota and say no, nobody else need to be allowed. No, ಅದನ್ನೇ ಅವ್ರು ಇಬ್ಬರು ಮಾಡಿದ ಪಾಯಿಂಟ್ ನಂಬರ್ 8 9 ಗೆ ನೀವು ಅದನ್ನ ಒಪ್ತಾ ಇಲ್ಲ. ನೀನ್ ಒಂದ್ಸಲ ನೀನ್ ರೆಕ್ರೂಟ್ಮೆಂಟ್ SC ST ಆಗಿರೋದ್ರಿಂದ ನೀನ್ ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಪ್ರಮೋಟ್ ಆಗಿ ಬಂದ್ರು ಸಹ ನೀನ್ ಮೇಲಿಗೆ ಬಂದಾಗ ನೀನ್ ಅಲ್ಗೆ ಹೋಗ್ತೀಯ ನೀನು.
Question of providing backlog vacancy and the representation would not arise. And the main objective is to maintain 59-3.
All right.
If there are more persons, because if in 100 candidates, there might be 20-30 candidates, 20 to 30% of candidates might be from among the SC and ST.
All right.
Their promotions cannot be denied, saying that your representation is filled up. Their representation has to be maintained if their representation is less than 50%. Once that is fulfilled, then senior. So for that, what's in case number 70, the earlier 97, the GO. Even in the recent circular, the inspections required in this 97 circular.
Page number? Page number?
Page number 70.
70.
Answer from page number 69. Relevant of 70. 9 is the preamble from 70. In number 8. In the foregoing circumstances, the government of Greece will take the following order. The promotions made on or subsequent to 27 April 1978 in all cadre services covered by the government order dated 27 April 1978 read at one go and the connected orders vacancies identified for personified these respective categories for want of eligible persons and filled by others are kept vacant shall be calculated and identified as backlog. To clear the backlog identified in the roster attached or to the government order dated so and so rendered to the above. In addition to the points identified for scheduled caste and scheduled right, the following additional points shall also be identified. Additional points and still that number is composed. Roman 3. All the promotions made against backlog in effect from 1990 in accordance with amendment and 3 above shall be reviewed in accordance with this order and the promotions of scheduled caste and scheduled right shall be adjusted and treated with reference to the local points annexed to this order along with the unreserved category. After effective review of promotion and adjustment and treatment application of item number 3 above, if some more persons belonging to scheduled caste and scheduled right who have already been promoted against backlog cannot be get adjusted in the want of adequate number of vacancies and as per the aforesaid closer point, such person shall be adjusted and treated in accordance with the procedure described in item number 3. While effective promotion in respect of future vacancies until such time shall be continued against supernumerary to be created by the concerned administrative department. For this purpose, it is there are certain items shall be deemed to have been modified accordingly. While adjusting and keeping promotees as indicated in item number 3 and 4 above, interstate seniority among the general category, scheduled caste category, and the scheduled right category shall be determined in accordance with 4A as the case may be of the Karnataka government. The roster points are made only for calculating the number of vacancies available for different categories on each occasion and they do not determine the seniority. Once backlog in reserve category is cleared, from that stage onwards, the additional funds on the post of identified as per item number 2 above shall be treated as unreserved. Now about the either number 8 in the affidavit about Muniraj and Manohar. As per the affidavit, for not treated as backlog vacancies as per the they were treated as per the legal opinion dated 8/5/2000. As on the date 8/5/2015, the new government or the there was a government order withdrawing the additional funds. If their argument saying that they were considered under the UR category, as per the opinion dated 8/5/2015, then what should government the promotion the guidelines in the government order dated 8/5/2015. That is now under 2015 guidelines. 2015 says and the 9 additional roster points are given. That could be replaced and the 33 roster points anywhere. Instead of waiting for the other additional points provided in that year. If that is applied, then there are 8 and 9 promoted. Fills up the backlog vacancy as per the 2015. Therefore, the question of again giving promotions to serial number 11 and 12, saying that they were backlog vacancies do not available. That is their affidavit. They have said that their affidavit. It is not said that it is not. They have not stated that they were considered under your category as per the recommendation of the BTC. They say as per the legal opinion. If that was the legal opinion, kindly consider the legal opinion when it was given. Subsequent to the legal opinion given by the legal cell in respect of the petitioner's case is concerned. Next day they give the legal opinion. That shows that the serial number 8 and 9 were promoted to the backlog vacancy. If their case is considered as on 8/5/2015, then they should have been considered under 2015 Contractual. If that is considered, then the case of the respondent saying that as on 2015 there were backlog vacancies takes care of 8 and 9. Therefore, the question of again reserving backlog vacancies to be serial number 8 and 11 and 12. Therefore, the entire experiment done by the respondent is they ask for their affidavit is based on the legal opinion. The promotions cannot come based on the legal opinion. Therefore, the legal opinion and that is also not a challenge legal opinion given by them. And also they say in the legal opinion they refer to the 2015 circular that government order. But on the legal opinion given in the next date, that is 8/2015, they do not refer to 2015 GO. Therefore, the promotion order of the respondent at annexure R and C of the
where is the order of promotion of this point 8 and point 9? Because if that promotion is against the reserved category, then the complexion changes again, isn't it?
The roster is clearly. The roster is there.
ಇಲ್ಲ ಪ್ರಮೋಷನ್ ಆರ್ಡರ್ ಬರ್ದಿರಲ್ವಾ?
Even otherwise, not to the restriction plots they have clearly. I would not pursue into the legal opinion. Because
So the order of promotion should make that clear, isn't it?
but the order of promotion plots would refer to the DPC proceeding.
So if they have considered the promotion on the basis of them being under the unreserved category, then the entire argument.
In the register, these a roster register. But where they have clearly indicated as on the date when they were promoted, that it was as against the unreserved category.
If the order of promotion indicates, then nothing. It's the indirect way of finding out. This is a direct way of finding out if they are.
Direct plots way of finding out kindly come to plots the notifications. But I be able to demonstrate plots whether they could have been considered plots as against the backlog post or
Now the corporation has taken the stand. It was not against the backlog vacancy. So first let us establish that.
Then establish plots. This is another way of plots.
Direct way badwa, indirect.
So this is also a direct way because kindly see this was 1978 government order plots that specified for the first time plots 33 roster plots. But just plot I make only 2 submissions. 1978 government order that specified this cycle loss, that is from 0.1 to 0.5. In that particular cycle loss, certain posts were reserved for scheduled tasks and one loss for this. The other lots were unscheduled. That was required to be followed lots without any deviation. Considering lots that there were many backlog vacancies which could not be filled lots by following that cycle. Then in 1997, the government lots came up with another circular, government lots, which provided lots the additional points so that lots could be filled. But once again, the additional points were given as against a particular number of lots and has to be filled as and when the backlog vacancies are there. In that particular place, the backlog vacancies are clear. Lots till 1997 till 2015, that was followed. What had happened lots is that the government considered on lots the request made by the several persons who did not get lots as and when the vacancies were available, which could not be cleared on account of lots 1997 circular or the government order, stating that it has to be cleared only at a particular number. Then lots the government withdrew the earlier government order, that is 1997 order, stating that you follow 1978 as and when you get the backlog vacancy, then immediately you clear. But this 1997 additional postal point government order was in existence till 2015. These two persons were lots could not have been considered lots in respect of a number, a roster number, which is not reserved for back or additional back. That is why lots they could not be considered as against the backlog. They were considered because of their own eligibility and lots.
If I get that confirmation from that matter ends.
That is all lots because 2015 government.
No, your argument is by implication.
Yes,
Your argument is by implication.
Yes.
So let us see if they are by chance.
Another lots is the register where they have clearly mentioned.
Register ಏನಂತ ಹೇಳ್ತಾರೆ?
Register this was not done pursuant to 2015. It was as and when lots they were promoted. Lots in the second page. It says the last two. This was supposed to come next page. There was that page. ಸಹಾಯಕ ಕಾನೂನು ಅಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡಿದೆ. ಪರಿಶಿಷ್ಟ ಜಾತಿ ಅಭ್ಯರ್ಥಿಗಳು
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ?
ಸಾಮಾನ್ಯ ವರ್ಗ.
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ಪೇಜ್ 18 ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ
When were they promoted, those two people?
They were promoted in 2011 and 12. 2011 and 12. One Lord Muriraju was promoted on 1/10/2011 and Lord Manohar was in 2012.
Lastly ಏನ ಇದೆನಾ? ಅಭ್ಯರ್ಥಿಗೆ ಲಭ್ಯವಿಲ್ಲಿತ್ತು?
ಸಾಮಾನ್ಯ ವರ್ಗಕ್ಕೆ
ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ ಲಭ್ಯವಿಲ್ಲ. ಮುನ್ರಾಜು ಅಂತ ಹೇಳ್ತಾರೆ.
Therefore, he is not having considered as an case. That is what he is telling.
ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ ಲಭ್ಯವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಹಾಗೂ ಅರ್ಹತೆ ಹೊಂದಿರುವ ಶ್ರೀ ಮುನಿರಾಜು ಇವರಿಗೆ
ಹಿರಿಯ ಕಾನೂನು ಅಧಿಕಾರಿ ಇವರಿಗೆ ಸಹಾಯಕ ಕಾನೂನು ಅಧಿಕಾರಿ ಹುದ್ದೆಗೆ
ವಾಟ್ ಅಬೌಟ್ ದಿ ಅದರ್ ಪರ್ಸನ್?
ಅದರ್ ಪರ್ಸನ್
Yeah, promotion order ಕೊಟ್ರೆ I think that will solve the issue.
If a promotion is available as the date when I mean, but though this 7 roster points was available for ST candidate, this Muniraju was not qualified to not.
We are only considered Munraju and Manohar Aligar.
Yes.
If these two promotion orders, Manohar dena ಒಂದೇನೋ ಕೊಟ್ಟಿದ್ರೆ I don't know. This is a note, I don't know for what, ಯಾವ್ದ್ರಲ್ಲಿ ಅಂತ ಗೊತ್ತಿಲ್ಲ. What about Manohar then? Along with the memo, file the order of promotion.
I read that is available here. ಅದರ ಕೆಳಗಡೆ ಮನೋಹರ್ ಅದಕ್ಕಿಲ್ಲ ಮುನಿರಾಜಕ್ಕೆ ಮಾತ್ರ ಇದೆ ಇಲ್ಲಿದೆ ನೋಡಿದ್ರೆ ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ ಲಭ್ಯವಿಲ್ಲದೆಯಿಂದ ಹಾಗೂ ಅರ್ಹತೆ ಹೊಂದಿರುವ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ
ಅಲ್ಲ, don't you have the order of promotion which will have indicated?
Promotion order will not indicate this thing.
But DPC should have indicated that DPC person.
Now disappear. That is why we have to fall back on the roster list itself.
Then file an affidavit to that effect.
Otherwise, they will have to produce it.
Yeah, this is the foundational fact, isn't it? Affidavit ಹಾಕಿ. Still argument. Argument.
In an election, cutting from post constituency is reserved for a particular category. Where if only person belongs to those categories, they can contest. Whereas not the other categories, that is the general categories, anybody can contest. Whereas it belongs to minority or reserved category.
Or reverse ಮಾಡ್ತಿದ್ದಾರೆ ಅದನ್ನ.
That is the argument.
This was the argument in the 371J also. Once you go onto 371J, you can't come out of it.
That is not by virtue of an order that does not.
No, that was by virtue of an option that the candidates are forced to give.
Option exercise.
Once you exercise the option, you can't come out of it. ಅದೇ ಪೊಸಿಷನ್ ಅವ್ರು ಹೇಳ್ತಿರೋದು.
That is the case brought in a unreserved constituency brought, no one can.
ಯಾವುದು? ಎಲ್ಲ ಜಿಯೋಸ್ ಇದೆಯಾ ಅದರಲ್ಲಿ? ಎಸ್.
This 3 was considered to interest and statement of government order, that there should be 3% to maintain the contract. And once 3% and 3% are achieved, then the rest will not follow. This is what was observed in the 3-99. Subsequently, 3-99 was amended on 13-499 page 25. But 2 paragraphs were added inside. Not I read only that portion. In paragraph 5 of the second sentence, starting with the words reservation in promotion and representation in the foreign shall be substituted into reservation in promotion in favor of persons belonging to shall continue to operate by applying the existing roster to the vacancies to the representation of the person belonging to scheduled caste as the case may be. The scheduled tribe reach 50% and 50% respectively. Now, for para 7 and 8, the following shall be substituted, namely, para 8 is relevant. Provisions of the government order dated 24/6/97, read at 7 above, will continue to operate until the existing backlog is clear. But while making any promotion thereafter in favor of the persons belonging to scheduled caste or scheduled tribe, their representation shall be maintained. The extent of 50%. So till the backlog is completed, question of representative not considered. Only thereafter the backlog, once the backlog is not filled, then only the representation. But question of this is not. I have been appointed against the 2% that is illegal acting on no. They were not on the list of the senior. They have been appointed.
No, but the entire case again hinges on 8 and 9. I believe that is.
What is that their promotions are not the DPC, but that has not been under challenge. Not, but our lords, if that is wrong, then certainly lords, that should have been lords assessed before this non report.
ಅದಕ್ಕೆ ರಿವ್ಯೂ ಅಂತ ಕೇಳಿದೆ ಎಲ್ಲದನ್ನು ರಿವ್ಯೂ ಮಾಡಿ ಇವಾಗ
Today the seniority list not showing that where those 2%.
and take it as reserved. You file that affidavit or memo, whatever you want. Word reserved. Council for BBMP is permitted to file an affidavit regarding the promotions that have been affected in respect of point number 8 and 9.
Last, there is last two lords in the middle one.
ಕಾಣಿಸ್ತಾ ನಿಮ್ಗೆ ಇದು
ಅದು ನಾನು magnifying. ಲಾಸ್ಟ್ ಒಂದು ಇದೆ ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿ ಲಭ್ಯವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಹಾಗೂ ಅರ್ಹತೆ ಹೊಂದಿರುವ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಶ್ರೀ ಮನೋಹರ್ ಅಲ್ವೇ ಕಾನೂನು ಅಧಿಕಾರಿ ಇವರಿಗೆ ಸಹಾಯಕ ಕಾನೂನು ಅಧಿಕಾರಿ ಹುದ್ದೆಗೆ
file an affidavit enclosing all this tape copy.
Number one, scale corporation. Now, state engineer is always going one. Again, I have been even to my post in place where
ನಿಮ್ ಎಲ್ಲಿಂದ ಎಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರೇನು ಗುರುಪ್ರಸಾದ್ you're in Bangalore, your posting is only given to another office.
postman is paid in charge of my post. I have been disturbed.
ನಿಮ್ ಕೊಟ್ರ ಪೋಸ್ಟಿಂಗ್ ಹೇಳಿ ಇವಾಗ is the same posting. You were in ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರ ಉಪವಿಭಾಗ.
ಈ ನಂತರ ಹೇಳಲ್ಲ and you also there is no need is only an assistant engineer. I am an assistant executive engineer. He posted to my place in charge with all the other post. Yes, honest the real order case 17.
There Subramaniya Chandrashud told in notice. Yes. AG to take notice for R1. She Subramaniya take notice for R2 and R3. Issue notice to R4. To the next date of hearing. The next area shall not be granted.
Are collected interest, penalty, and double tax amount from the landowner. For this tax or fixed by the.
How can I grant an interim order of stay of all for the proceedings pursuant to a disciplinary inquiry?
First, kindly refer to the, first kindly refer to.
Now, whatever you argue, Ramesh, is on the merits of the charge. Isn't it?
Yes, Lord.
Then
Only one order.
if I grant an interim order, it amounts to staying the dismissal proceeding, isn't it?
Because I stick by the immediate whatever, let them not take any course action.
ಎರಡು ಒಂದೇ ತರ.
For this reason, Allah. For this reason.
What is the illegality in the issuance of a charge sheet?
Yes, Lord. For this connection end, page 104. The joint commissioner has specifically heard an inquiry against me based on the complaint filed by one Navin Kumar. Kindly refer to page 106.
Notice though, I am not convinced.
For this reason, 106 ಅಲ್ಲಿ, very same joint commissioner has recorded finding that I have not committed any offence.
Is this joint commissioner's report accepted by the highest authority there?
It was not there before the joint commissioner of revenue.
Honest.
He has given the contrary finding at page 125.
Take notice, let us see.
give them, not, let them not take, not coercive action.
May Subramanian take notice for respondents. Released on, nothing is going to happen within a week or something.
Why this proceedings have been initiated after last?
Rameshwara, will anything happen within a week? ನೀವು ಬಿಟ್ಬಿಡ್ತೀರಲ್ಲ, ನೀವು ಅಲ್ಲಿ ಬಿಟ್ಬಿಡ್ತೀರ ಎನ್ಕ್ವೈರಿ ನಡೆ ಬಿಟ್ಬಿಡ್ತೀರ ನೀವು ಇಲ್ಲಿ ರಿಟ್ ಹಾಕಾದ್ಮೇಲೆ.
This was, this honorable court has granted an interim order of stay of my transfer. That order has been produced to Monday.
No, take out notice letters.
Connection team that have taken part. There are made some allegations. Saying that I have filed petition because the reports against the highest official. Thereafter, with the annexed jailers, I have been. The order of the depression has been retracted and
Annexed J challenge ಮಾಡ್ತಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಹಿಂಪಡೆಯಲಾಗಿದೆ. 7/7/23 ದೇಶದ ಹಿಂಪಡೆಯಲಾಗಿದೆ.
ಏನಕ್ಕೆ? ಇದೇನು? This is from the principal secretary. No, but this is a direction issued to the deputy commissioner from the principal secretary of the housing department. You know, you seem to have annoyed a lot of people. AGA to take notice for R1 and R3. ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆದ್ರು ನಿರ್ಮಿತಿ ಕೇಂದ್ರ ಆ ಕೇಸಲ್ಲಿ ಹೂ ಅಪಿಯರ್ಡ್? ಅಲ್ಲ, ಗೀತರಾಜನ್ ಅಪಿಯರ್ ಆಗಿರಲ್ಲ ಅವ್ರು. Issue notice to R2. In the next date of hearing, annexed J shall stand state. Handle permitted. What is annexure C?
Annexure C is the impute order not effective. Not the general manager. Basis that works to the general manager on the report of the general manager. Based on the allegation.
ನಿಮ್ಗೆ ಆಸಕ್ತಿ ಇಲ್ಲದಿರುವುದಿಲ್ಲ. You have no interest in working.
No, that is the allegation. There is no inquiry. There is no notice issued. I see words of the allegations for allegation transfer allegation. The basis of allegation of that action becomes everybody from different by order of the base connection D. Paragraph 11.4 cross the kind of seen drop.
ಏನಲ್ಲ, you have no right to continue there. They don't want you, they don't want you. Deputation ಗೆ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಡೆಪ್ಯುಟೇಷನ್ ಗೆ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಟೆನ್ಯೂರ್ ಇದೆಯಾ? ಡೆಪ್ಯುಟೇಷನ್ ಗೆ ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ವಾ? Correct. You are deputed to this particular ಯಾವ you are deputed to Bescom. Now that order of deputation is withdrawn. How can you apply this GO for transfer?
It's just that without the consent of the lending and the borrowing department, and deputation cannot be effected. Here, once the deputation, I will send a deputation to Discom. Discom will not have to consult with the Building department, that is KPTC, without even consultation, they have prepared everything. I have also produced a
So who should object? Who should object? If the parent department has no objection, they may be affected. Your argument is on behalf of KPTC. They have no objection.
Without the knowledge, not they have to be.
They let them file a writ petition saying that they could not have done this. You are only the
That's what I should not kindly see.
deputation ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮ್ permission ಕೇಳಿರಲ್ಲ ತಾನೆ ಅವ್ರು.
The guidelines is also.
Before they deputed you, they did not take your consent.
It is only on the basis of allegations, not.
Objections ಹಾಕಿ ಮೇಡಮ್ ನೋಡೋಣ.
What for interest rate, not. Otherwise, kindly see not.
I am inclined to dismiss the petition, but I just want to hear them before I dismiss the petition.
It is only on the basis of report submitted to judge. Not giving any opportunity, but they have.
Okay, ನೋಡೋಣ, let us see what they will say.
If you go to law practice, you are starting.
Then Srimati Rakshita to take notice for respondents. Relist on.
So only allegation is not considered unapproved, they accept.
ನೋಡೋಣ ಇರ್ರಿ.
Even I have assigned lot.
ಒಂದ್ ವಾರ ನೀವು ಇಷ್ಟು ಅಲ್ಲ ಇಷ್ಟು ಕೆಲಸ ಮಾಡೋ ಮುತುರ್ಜಿ ತೋರಿಸಿದ್ದೀರಿ, ಆರ್ಡರ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ನಿಮ್ಮ ಮೇಲೆ ಇರೋ ಅಲಿಗೇಷನ್ ನಿಮ್ಗೆ ಉದಾಸೀನ ಅಂತ. I will not be able to take your statement on the face value letter or.
The representation of committed work, the son is suffering from febrile seizure, on that ground, I applied for leave. Kindly see that.
ನೋಡ್ರಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡ್ರಿ. What will happen?
Somebody will be posted in that much work,
I don't have the power to set aside that order then. And they keep quiet for 1 week, what will happen? If there is a case for interim order, I will not even trouble you people.
Kindly see the 11.4. Paragraph 11.4.
I will consider your case for interim order on the other, and then the next date after I hear them. Wait for a week.
The same.
6160 ಎರಡು ಒಂದೇನಾ? Who's for the other side? She agrees or does not agree?
There is a border protection. What would basically.
What exactly is the prayer in this petition?
One, declare that fisheries within the guidelines issued by the NHC as medical services, but as ultra wide, or in the alternative to declare that it does not apply to the petition for appointed prior to the guidelines of the proposed.
This is an interim order.
So the final one. Number what has been done is for the third, second.
Who appears for NMC?
But Mr. Jyoti, she is agreeing for that. Now, what NMC itself has not issued a clarification.
Where?
State that is recorded in this order. So can I request for please turn to page 3. Second paragraph refers to this very good guideline. Please turn to paragraph 4. The way to see the response that you are supposed to comment in the perfection and clarify its position as per the guidelines that this not amended to clause 6(2) of PMB guidelines 2023 is that we have only prospective event and is meant for only those teaching faculties which are appointed after the guidelines of the course.
You agree to this position? You agree to this position? Why not counsel appearing for NMC submits that the issue raised in this writ petition is covered by a decision rendered by the Allahabad High Court in writ -A number
18482/2023, in which the Allahabad High Court has taken note of the submission of the council appearing for the NMC, that the guidelines that have been issued is meant only for those teaching faculties who had been appointed after the guidelines had come into force. It is also recorded in the said order that the effect of that the
Actually, balance the other. Inform the event of
It is also recorded therein that the effect of CBMA guidelines to 2023 would not disturb the old faculty, and they would continue to remain eligible for becoming the examiner, and that the CBMA guidelines 2023 would be applicable only to new appointments. In view of the statement by the Learned Counsel for NMC, this writ petition is disposed of in the same terms as in writ dash number A number 18482/2020, passed by the Allahabad High Court on 3/11/2023 in the neutral citation with the number. Whatever is there, I have done. That is all. ನಿಮಗೆ ಒಳ್ಳೆ ತಾನೆ ಬಂದ್ರೆ 62 same 61 62 same. Whatever terms she has agreed, I'll say. If she says anything else, I'll add to that. It's not my order. It's whatever she is saying. In that case, you'll argue differently. In Satish, ನೀವು ಒಪ್ಸಿಲ್ಲ ಅವ್ರನ್ನ. KT is agreeing that only it's covered only with Manmohan's case, not with your case. I'll pass that order. If there's any difficulty, make a mention. I'll recall this order.
They don't think that. Which is not correct. He was not there in the selection of
What was the order? Order code? Order. R4. Who was R4? ಇದೆಲ್ಲ ನಾನ್ ಮಾಡಿದ್ದು. When was my order? When did I pass the order to file an affidavit?
Which one is right?
Did I pass any order specifically?
Ask for
Order in Madilva?
get the submission.
No, Narendra, let us see. I'll examine it afterwards. ಹೇಳ್ತಾರೆ, let us give him some time. ಹಬ್ಬದ ಟೈಮಲ್ಲಿ ಯಾಕೆ ಕೊಡಬೇಕು ಅಂತಾರೆ ಅವ್ರನ್ನ? If there's anything, please ensure that it is undone.
It's number.
And who will decide this 2002? I didn't touch list number 2 at all today. No, but these are new matters relatively, so that I'm giving it second priority. First priority is 2011-12. The other people have been dismissed from 2011. I think they are.
Serial number 3 in the second list, Malone. It's it not survives for consideration, Malone.
ನೀವು ಯಾರಿಗೆ?
I'm for the petitioner.
That comes for the petitioner submits that the prayer struck for in the petition would not survive for consideration. Recording the statement, the petition is dismissed and will become unnecessary.
Nice.
ಅದರಲ್ಲಿ
ಎಲ್ಲ dispose of for second list.
Court officer. Court officer. Court officer. Serial number 15 list 2 ಏನಾಯ್ತು ಸರ್?
ಮೇಡಮ್ ಅದೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಮೇಡಮ್ 18th ಗೆ.
ಹೌದಾ? ಓಕೆ ಓಕೆ. ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.